Call to get to order our regular city council meeting. The date is October 4th. The time is 6 p.m. Madam Clerk, roll call, please.
Mayor Ronnie Felder. Mr. Chair, let the record reflect that the mayor did send in correspondence today that he wouldn't be here tonight.
Thank you, Madam Clerk.
Chairperson Douglas Lawson.
Here.
Chair Pro Tem Shirley Lanier.
Here.
Councilperson Troderick McCoy.
Here.
Councilperson Kashamba Mill Anderson.
Present.
Councilperson Julia Botel.
Here.
Jonathan Evans, City Manager.
Present.
Tawana King, City Clerk is present. Don Wynn, City Attorney.
Here.
Mr. Chair, tonight we have our Pledge of Allegiance recited by Ms. Marlee Whipple.
Thank you, Madam Clerk. If we can have a moment of silence followed by our Pledge of Allegiance, it'll be led by Ms. Marlee Whipple. Her mother's here with her tonight, Ms. Campbell. Marlee, she attends JFK Middle School and she's an honor roll student. She's also a Safe School ambassador and a part of the newspaper club. She even participates on the flag team with the band. When she gets older, she wants to be a lawyer and attend Harvard Law. But for today, she's going to keep striving for greatness. Welcome, Ms. Marlee, and thank you. If you can, lead us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Ms. Marlee. Madam Clerk, do we have any additions, deletions, or substitutions from you or staff?
Mr. Chair,
Dr. Botel?
sorry, just asking if we could move resolution number 143-23, item 11B to consent. It's an acceptance of a grant.
11B,
B as in boy.
thank you. Board members, are we okay with that? I was also going to inquire if we could move item 11A to consent.
That's fine with me.
Board?
Well,
Councilman McCoy?
so my concerns with 11A, I guess, is there nothing, this is the actual expenditure, but we've already accepted more or less the grant,
Yes, sir.
correct?
Yeah, we accepted the 600, so there's the difference of about 105,000 of our expenditure. So the grant was, I believe, 600,000.
Well, I would like to kind of ask a couple questions on that, if you don't mind.
Yes, sir, we'll leave it as is. So we can only move 11B to consent, board.
Mr. Chair, if I may,
Mr. Evans, please.
I would ask that the board indulge staff to allow for me under discussions and deliberations by the manager to obtain direction from the board on a couple of items, one being your fiscal year 2023-2024 legislative priorities for both the state and federal government, requests for strategic direction concerning an engagement with the Palm Beach County School District in as it relates to the correspondence that I sent to the superintendent of schools, and then direction on the proposed calendar or schedule for the remainder of the year for the city council, CRA, and utility special district.
That'll be under the city manager discussion.
That is correct, Mr. Chair.
Thank you, Mr. Evans. Additional comments from the board?
Motion to approve the agenda.
Second.
Motion been made, properly seconded. Madam Clerk?
Councilperson Botel.
Yes.
Councilperson Mill Anderson.
Yes.
Councilperson McCoy.
Yes.
Chair Pro Tem Lanier.
Yes.
Chairperson Lawson.
Yes.
That vote passes unanimously, Mr. Chair.
Thank you, Madam Clerk. Consent agenda. All items taken under consent are routine in nature and disseminated with one vote. If anyone wants to pull an item from consent, please do so now.
Motion to approve the consent agenda as amended.
Motion has been made.
Second.
Motion been made and properly seconded. Madam Clerk?
Councilperson Botel.
Yes.
Councilperson Mill Anderson.
Yes.
Councilperson McCoy.
Yes.
Chair Pro Tem Lanier.
Yes.
Chairperson Lawson.
Yes.
That vote passes, Mr. Chair, unanimously.
Thank you.
You're
We'll go now into awards and presentations. 6A.
Item number 6A, Volunteer Association and Fund of Florida and Florida Rising honoring Police Chief Michael Coleman. And Mr. Chair, this item is presented by Ms. Deirdre Jacobs, Assistant City Manager.
Welcome, Ms. Jacobs.
Thank you. Good evening, Chairperson Lawson, other council persons in your respective places, City Manager Evans, City Attorney Nguyen, and Mrs. Smith, City Clerk. My name is Deirdre Jacobs, and I'm the Assistant City Manager here with the City of Riviera Beach. On this evening, there's a nonprofit organization that wanted to recognize our police chief, Chief Coleman. The name of the association is Volunteer Association and Fund of Florida and Florida Rising, honoring Police Chief Michael Coleman. There was one of our police officers explained that the particular organization would be here tonight, but it appears as though they were not able to make it. So we apologize for the inconvenience. Okay. You're welcome.
Well, we have no problem celebrating and honoring our staff. And Chief, thank you for the work you've done in this amazing award on behalf of the City of Riviera Beach. Thank you.
Thank you.
Chief.
Madam Clerk, 9A.
Ordinance number 4237, an ordinance of the City Council of the City of Riviera Beach, Palm Beach County, Florida, approving an application ZA 22-0003 from JS 12 Real Estate Holdings LLC applicant, requesting a zoning map amendment to rezone the western portion of the subject property from the downtown general DG zoning district to the downtown core DC zoning district, and providing for an effective date and for other purposes. Mr. Chair, we do have public comment cards on this item. The acceptance of public comment cards for item 9A is now closed.
Motion to approve ordinance number 4237.
Motion been made and properly seconded. I'm sorry. Do we have a second? Motion been made and properly seconded. Mr. Evans? We'll go right into Mr. Sermons.
Thank you, Mr. Chair. Good evening, members of council, Madam Attorney. For the record, I am Clarence Sermons, Director of Development Services for the City of Riviera Beach. I will move into the presentation for the item just read into the agenda. There are two parts to this project that are included in the agenda that was just written into the record, as well as a second application for abandonment. My presentation will encompass both of those items for clarity purposes. The project location is indicated by the red dot on the screen before you now. The image now before you shows a closer aerial version of the property in question, and it is surrounded in a red square. The image to the left is a view to the property from the northeast. To the right is a view from the north of the property in question. To the left on this screen is a view from the southeast looking at the property, and then finally a view from the south looking at the property. The petitioner has submitted this application to request several applications to allow a 30,358 square foot, two-story boat dealership with an outdoor boat storage area. The existing site is vacant except for a vacant building. The parcel IDs are indicated on the table on the screen, and the lot is approximately 4.01 acres. The current zoning is downtown general as well as downtown core. The future land use designation for the property is downtown mixed use. On the screen before you now is the current zoning of the area. To the right in the pink color is the downtown core zoning area, and to the left is downtown general. The applicant is requesting to rezone the entire block to downtown core, which would allow a continuous zoning throughout the properties and for the desired uses to be allowed throughout the entire property. The request also requires an abandonment of an existing 20-foot alley that crosses through the property in two different locations here and here. The abandonment of this alleyway would allow the applicant to replat the entire block into one parcel to allow the desired use. This project has been reviewed by multiple departments, operations, and outside entities before coming before you today. Staff has reviewed the rezoning request against the 8 rezoning review standards and found that the application meets those standards. Additionally, staff has also reviewed the abandonment application against the city's roadway abandonment criteria and found that this application satisfies the criteria. The project was also reviewed as it is in the CRA by the CRA board and found to be in compliance with the CRA master plan. This project was noticed according to state and city regulations, and all notices and evidence of those notices are provided in your backup. Staff received 2 points of community feedback from this project in the way of emailed letters. Both were letters in opposition. Those persons attended the Planning and Zoning Board meeting for this project and provided feedback. There were additional conditions added to this project regarding screening based on that. I understand even since the Planning and Zoning Board meeting, the applicant met in good faith with those same community members, and additional changes were made that I'll identify in a moment. But for the purposes of that, to orient you to how the site would be laid out if it moves forward.
Mr. Chair.
Councilman McCoy, go ahead.
So I would respectfully ask that we don't go into the site plan, because what you're doing is you're giving us 2 separate items that we're voting on. Number 1 is the rezoning, and then the second being the abandonment. I think it's very premature to take the site plan at this point. And I do want to ask a question regarding the communications that you got in opposition, but I think that's not ripe before the board at this point. And I think before it's actually properly presented, you could create a situation where you're going to have members that could be potentially prematurely prejudiced by reviewing a site plan before it's formally presented. So if we could take a step back, the two communications that you got in opposition, what exactly were they opposing? The site plan, the abandonment, or the rezoning?
And the reason I included those, because to your point, the site plan is not before you. Typically, when we get community comments, they don't often distinguish between which application that they are specifically commenting on, and they'll respond to the project as a whole. Staff thought it inappropriate to omit these community responses just because they may have mentioned specific aspects of the proposed site plan. Many of the comments also reference the use itself, which is in question tonight, because the zone change that is being proposed would allow for that use to take place throughout the parcel. The reason that that visual that was just on the screen is included because those conversations with the community members who were initially opposed to it discussed screening measures that would allow for them to maintain what they believe as a better quality of life if this use moves forward. So again, those comments are included because they are in regard to the use that is being proposed here, and the use is in question through the zone change ordinance that's being proposed. The site plan is not, and to your point, Councilman, that is not a part of the review criteria for a zone change or an abandonment, but the community comments were in regards to the neighborhood being screened from the proposed use.
Mr. Chair, follow up.
Councilman McCoy, go ahead.
Okay, and it's very important to distinguish that, Mr. Sermons, and I think you did a great job, but specifically because there's a provision in our code that speaks to ex parte communications, if that is going to be presented or proffered or even mentioned, then it needs to be provided a part of the record, and for all intents and purposes, when we get to that point of actually hearing a site plan, I would expect that those communications be provided to the board because of the quasi-judicial nature of a site plan. Perhaps not the abandonment, but certainly the site plan. And that section is 2-46. That pretty much speaks specifically of the procedure in those documents being made a part of the record. So that's why I would ask that we don't go into the site plan, because unless you're going to give me those communications, which we're not going to vote on tonight, I think is kind of improper.
The communications are included in the backup for this item.
Right, but we're not voting on the site plan. If they're relative to the actual use, arguably, we don't have to consider it, but certainly if you're considering the site plan or any elements thereof, or you're going to show us a rendering of the site plan, I think that's the portion that becomes almost like we shouldn't even discuss it until it's before us.
If I may, I just opened the community comments as we were speaking, and they do specifically mention the zone change application. So
Okay.
it is appropriate to include
Okay.
in the conversation.
All right. Thank you.
Yes.
Thank you, Councilman. Ms. Sermons?
But again, as we make it a point to induct the community comments and feedback into any a review process, we've included those comments and noted that those community members, many of their concerns were addressed if the applicant or if the use that is provided there has sufficient screening. So without, and I'll skip past the visual of the proposed layout. With that, there were two conditions that are related to the zone change and the abandonment. As these are ordinances, they are not subject to conditions. However, these conditions would be attached to future applications for the site plan if this moves forward. One being the condition that for the abandonment, the privilege fee of $114,246.36 associated with abandonment application AB 23-0001 shall be paid within 30 days of approval by City Council, or the site plan shall become null and void. Again, that's connected to the privilege fee that is required of abandonments. So a condition would be included in that if this moves forward. And then subsequently, condition 10 that would be attached to the future document would be regarding the fencing and what was discussed between those residents and the applicant, and also at the Planning and Zoning Board meeting. And it, again, it's connected to this application because those, based on those conversations, the community members felt that with proper screening being a wall in this instance, that the use could be acceptable for those living near it. And aside from that, staff recommends approval of this application. And of course, I am here for any questions that you may have. The applicant is also here and has prepared a presentation for you.
Thank you. Let's hear from the applicant. And
Good evening,
let's hear
Wayne.
from the applicant.
Thank you. Good evening, Wayne Richards, for the record. Mr. Chairman, council members, staff, very happy to be here today. We will not give a presentation. The presentation, unless you so desire. The presentation that your staff gave was very thorough. We do not wish to discuss the site plan. The good news is this: two wonderful community individuals showed up at the Planning and Zoning Board meeting, and they had concerns. They were not very upset. They said, we want more screening. My client wholeheartedly agreed. We met with them in my office, and they promised to be here tonight. They said they would be here in support, but they're not here. The good news is they're not here complaining, but they do support it. And we have agreed to additional fencing on their behalf. So the community is not against it. They told me they support it. It's consistent with your plans, and we ask that you please approve it. It's a phenomenal project, but I don't wish to go over the site plan today. Hopefully we'll go over it in 2 weeks. The entire team is here. If you do want a presentation or if you have questions, we're here at your disposal. Thank you.
Thank you, Senator. Any public comment, Madam Clerk?
Yes, Mr. Chair, we do have one public comment card. Mr. Lloyd Brown.
Let's hear from public comment first.
Doug, tell him what he has to do to get us.
How you doing? My name is Lloyd Brown, and I'm exercising my First Amendment rights, freedom of speech, press, assembly, and the right to petition the government for redress of grievances. And you know, I'm talking about all these items you got here, because for one thing, they're not doing anything for a person like me. And so instead of me coming up here giving you a comment, which is not a comment, that's what you want to call it, I have problems, and the people that come in here have problems. And when they come in here and they tell you their problem and you talking about thank you for your comment, that's just your asinine way to say like you accept what they're saying, but you're not going to do nothing about it. And like I know what's covered under the First Amendment, so like if you got anything to say about what I'm doing, go ahead. There's a couple of lawyers looking at this right now. And let me just tell you about the first thing about, okay, the First Amendment, it protects speech, religion, press, assembly, and the right to petition the government, which is you people. And I'm gonna tell you the honest truth. Profanity is not even, it's covered under the First Amendment right. Like if I shot a bird at y'all, you couldn't do nothing about it. So like, if you wanna put me down, cause these last few seconds I got, I'm just gonna stand here and listen to Umar Johnson on my radio. Cause I'm not thinking about you don't do nothing for us, for the people like me. And then what in the heck this place coming in here that you're talking about right now, how is that gonna affect an individual like me? Not at all. Not at all. So like I'm not talking about what you're talking about because I'm using my First Amendment rights. And they said, oh, you know, we got this place moving in over there on 13th Street. And then you subcontract out 8th Street to some company who the public utility was doing. And then I'm saying, now that's stupid. And then Riviera Beach, right at S Avenue, the public works don't do that no more. You got some immigrants coming there doing that. So you talking about the company that came over there, all right, they hired, that's 2 steps forward and 30 steps backwards. And I'm gonna tell you like this, for my Nate, I got a couple cars in there. And you're not gonna hear what I really gotta say until I get to the public grievance, not comment. It's a public grievance. It's not a comment. And if you wanna tell one of these officers to sit me down, I'm glad. Y'all ain't seen nothing Lowe's been done to you. Come on and put me down. If you don't like what I'm saying, sit me down. Send the man over here and let him grab me and put me in my seat. And I will. You think you got a lawsuit, you'll have one bigger than that. And I'm gonna tell you, I'm just gonna come here and I'm not gonna say nothing because you don't get nothing done by talking.
Thank you for coming, sir. If you want to make a comment, you have to submit a public comment card. So actually see the young lady over here and she'll get you a public comment card. Chris, can you get this gentleman a public comment card, please? Thank you. Any additional comments, Madam Clerk?
No, sir, that's it.
Thank you. Board members? Comments from the council? Madam Clerk, roll call.
Councilperson Botel,
Yes.
Councilperson Miller Anderson.
Yes.
Councilperson McCoy,
Yes.
Chair Pro Tem Lanier,
Yes.
Chairperson Lawson.
Yes.
That vote passes, Mr. Chair, unanimously.
Thank you. We are going to actually go back. We do have a presentation for Chief Coleman, but we will actually have that right after we dispose of this second ordinance. Mr. Sermons did give a presentation for 9B, but we do need to dispose of the item as well. So let's go into ordinance 4238. And then if it's a pleasure of the board, if we can go back to Mr. Awards and presentations. Madam Clerk?
Ordinance number 4238, an ordinance of the City Council of the City of Riviera Beach, Palm Beach County, Florida, approving a request from JS12 Real Estate Holdings, LLC applicant requesting an abandonment AB-23-0001 of the following right-of-way segment, the 20-foot alley, right-of-way utility easements, and required right-of-way dedications along Broadway and Avenue E in Riviera Beach, Florida, attachment A, and providing for an effective date and for other purposes. Mr. Chair, we do not have any public comment cards on item 9B. The acceptance of public comment cards are now closed.
Motion to approve ordinance number 4238.
Second.
Motion been made and properly seconded. Mr. Evans?
Excuse me, Mr. Chair, I apologize. We do have one public comment card.
Thank you, Madam Clerk. Mr. Evans?
Mr. Chair, members of the board, if I could have the Director of Development Services, Mr. Clarence Sermons, to make this presentation.
Thank you, Mr. Manager. Mr. Chair, staff does not have an additional presentation for this item.
Thank you.
We are available for questions, of course.
Abandonment, board members, we do have a public comment. We'll go to public comment first.
Yes, Mr. Lloyd Brown.
Thank you.
I stand here and listen to this thing I got on my ears because I'm protesting because you don't do nothing for nobody, especially people like me. You get up here every Wednesday or first of the month and you talk big and you express all these ideas.
Mr. Brown,
Hey,
abandonment
look,
is a
wait a
discussion.
minute, wait a minute now, wait a minute.
Yes, Mr. Brown.
I'm exercising my First Amendment right. So you want the man to come and take me off, then do that. Don't talk while I'm talking.
It's
It's not your turn.
Germane to the
doesn't
item,
matter.
Mr. Brown.
It's not your turn.
Abandonment, sir.
I got 3 minutes.
To talk about abandonment, or you can stand in silence.
Hey, look,
Either
I
one.
got 3 minutes. Well, I talk then.
I
Let me
understand.
talk. No,
Go
look,
ahead and
just be
talk.
quiet, man. It's my 3 minutes.
Absolutely.
Well, then just shut up.
Yes, sir.
Shoot.
Thank
You
you,
don't
Mr.
like what I'm saying? Then get another job.
Brown. Understood.
Go somewhere else and screw up a city. Get out of this one. So don't come up here telling me what I can't do and I can do. I know my rights. I might not look educated or wear a tie and a suit, but I got more knowledge than you would think. So don't come telling me about your problem.
Remain to the item, Mr. Brown.
Hey, I don't have to talk on item. I'm protesting
you
your
do,
item.
Mr. Brown.
No, I
Or
don't.
you
If
can-
I'm
or
in
you can remain
protest,
silent.
no, you tell the lawyer that out there who's listening.
Understood.
I'm protesting. I have the right to protest in any way I want to. If I wanted to stand on my head right here, say I'm protesting, you can't do nothing about it. That's my First Amendment right. That's how it is in America. I don't know where you from. So don't come up here with this BS telling me about what I need to do. You just listen, because that's your job. Don't tell me anything, anytime, anymore. Like I say, you here and you don't do nothing for the people like me. You just here. Yeah, I would leave too. And you know what? What I got to do? I got to come back over here in a different uniform when I ask y'all a question about helping me out for different problems. I've been here 10 years asking the council members to do something. I don't really care now. But I'm going to tell you like this. Don't ever tell me about what I can't do on my First Amendment right. If you're going to do anything, just send one of them officers over here and make me rich. That's all I'm telling you. Just send one of them over here. Other than that, you need to be quiet because it's not your 3 minutes. They are my 3 minutes. And I don't work for you. You work for me. So I don't want to hear that BS you telling me about what I should do. If you're mad, I'm sorry. You just have to sit on it.
Thank you for your comments, Mr. Brown. Let the record reflect, Kashama Miller Anderson left the dais at 6:28 p.m. And before we go on, let me just remind our public, decorum, civility. This board has adopted the rules of decorum for operations for civil meetings. While we accept and we adopt free speech, we allow for discussion to be freely held. This is a elected board that will be respected. And understanding that you can always speak your mind with any item, but we're here just doing a job for the people of this community. So please have a respect and sense of decorum and civility for your elected officials. Board members, let's go into discussion, please. Madam Clerk?
Councilperson Botel,
Yes.
Councilperson Miller Anderson,
Yes.
Councilperson McCoy,
Yes.
Chair Pro Tem Lanier,
Yes.
Chairperson Lawson.
Yes.
That vote passes, Mr. Chair, unanimously.
Thank you, Madam Clerk.
Mr. Chair, also let the record reflect that Ms. Miller Anderson returned at 6:30.
Thank you, Madam Clerk.
You're welcome.
Board, if we can go back and revisit the awards and presentations. Volunteer Association Fund of Florida and Florida Rising honoring our Chief, Honorable Chief Coleman.
Good evening, council persons. Good evening, Chair. My name is Dr. Martine Sonatas, board certified psychiatric mental health and family nurse practitioner. I and the Board of Volunteer Association and Fund, in collaboration with Florida Rising, would like to honor Chief Coleman tonight with an award for his service within the community. Chief Michael Coleman is an exceptional individual with a caring heart and commitment to work within the community. We sincerely appreciate your commitment to our organization, and on behalf of the Board of Directors and our partner organization in the Haitian American community, we thank you for keeping the vision alive. May the Lord bless you, your family, and all your endeavors. Thank you so much.
Thank you.
And on behalf of the board, we wanted to thank you for honoring our amazing chief, and thank you for continuing to support our city. Madam Clerk, ordinance 4196, 9C.
Ordinance number 4196, an ordinance of the City Council of the City of Riviera Beach, Palm Beach County, Florida, amending City Code of Ordinances, Chapter 27, Planning, Article 2, Administration, Section 27-31, entitled Created Member Quorum, Term, Vacancies, Removal, in order to change the title of the section, provide guidance on procedures for appointment of regular and alternate members, establish the number of members and alternate members, and establish general qualifications for board membership, and amending Chapter 27, Planning, Article 2, Administration, Section 27-33, General Duties, by amending the reference to Planning Board and adding a board member participation and training to the list of general duties of the board, providing for applicable conflicts, severability, and codifications, and providing for an effective date. Mr. Chair, we do have public comment cards on item 9C. The acceptance of public comment cards for item 9C is now closed.
Motion to approve ordinance number 4196.
Second.
Motion been made and properly seconded. Mr. Evans?
Mr. Chair and members of the board, if I can have the Director of Development Services, Mr. Clarence Sermons, to make this presentation.
Thank you, Mr. Manager. Good evening again, Mr. Chair, City Council, and Madam Attorney. The item before you now has been discussed multiple times, and the genesis of it was the last few reappointment hearings for members of the Planning and Zoning Board, and there were concerns and dissatisfactions expressed from the board to staff about the appointment or reappointment process for the Planning and Zoning Board. So for over a year now, staff has been working on an amendment to the code that governs the Planning and Zoning Board to provide something that would be satisfactory to council. And we hope this document is that. The main changes that we are looking to accomplish with this amendment are one, create equity and district representation across the city so that elected officials have the same number of appointees, and to ensure that there is someone appointed from each district that the city is divided amongst for representation. Also to refine the criteria for selection of Planning and Zoning Board member appointees of volunteers. So this criteria would provide some guidance which did not exist before, and what qualifications should be sought or looked for. And finally, to provide required training for members of the Planning and Zoning Board. And we've discussed this individually and at previous meetings. So staff is happy to ask any questions that there may be on this item.
Madam Clerk, public comments?
Yes, Mr. Chair, we have Mr. Lloyd Brown and Mr. Fane Lozman. Mr. Lozman, you submitted 2 cards for the same item. So if you want to change the item number on the second one, you're more than welcome.
Since you're telling me My name's Lloyd Brown. Since you're telling me I got to conform, let me tell you something. This is a meeting, and the Constitution and all that, it protects me. So, like, whatever you think I should say or what I should be saying to you has nothing to do with what I'm talking about. And I'm not talking about anything that you putting up here or whatever. I'm going for my 3 minutes, and those are my 3 minutes. You need to look on the web and find out what happened to other people in other places, bigger cities like Los Angeles, where this man, he was talking like I am. Go ahead, put me out. Do what you want to do. I'm ready for it. Like I said, I could use the money. I really can. And I'll be honest with you.
Mr. Brown,
Because it's terrible. No, it's
make sure it's
terrible.
about the item,
Hey,
Mr.
I'm
Brown.
talking, it's terrible that I can get up here for my 3 minutes and say what I want to say, because I'm not up here to talk about your agenda item. I'm protesting the government that you have over here.
Mr.
So I
Brown.
don't know. I'm protesting the government. Now, if you keep it up, then I will have a lawyer to
Walter,
come.
Walter, please pause this time.
Yeah, go ahead. Walk me out. Where you at?
Walter, please pause this gentleman's time. Mr. Brown, your time was paused
Okay.
at
Well, let me
1:40.
talk about the agenda
Mr. Brown,
item.
under general
Let me
public.
talk about the agenda
Mr. Brown,
item.
I paused your time, and I will be
Hey,
clear.
let
so
me
you can-
talk about the agenda item. You know what? It
Mr.
sucks.
Brown, no. Let me understand. Thank you, Mr. Brown. I understand. Thank you, Mr. Brown. Mr. Lozman, welcome. Thank you, Mr. Brown. Madam Clerk,
Mr. Fane Lozman.
thank you.
Thane Lozman, just a point of order. It's disorderly conduct to talk about an item to talk about something else when it's an agenda item. So that's actually considered almost a criminal offense. You can be arrested and removed from a meeting. So if we're talking about 9C and somebody decides to talk about putting a new roof on the building, you can't do that. During non-agenda public comment, you can talk about whatever you want to, but you got to be careful because the courts have ruled that if you're off topic, you can be removed. If you don't want to leave, you can be arrested for disorderly conduct, or if you go beyond your 3 minutes. So just be careful about that. Now, if there's a point of order, if the board is doing something wrong, you can take a couple minutes at the beginning before you get into your agenda item. Like the chair went and read some rules here. Before I get into the agenda item, you said no clapping. Well, we just had a bunch of clapping from the audience when the police chief got an award. So what determines when you can clap? What determines when you can't clap? You either have no clapping from the audience or you have clapping, but you can't have a double standard in the rules of decorum. As a matter of fact, in some courts, these rules of decorum have been found to be unconstitutional, but I'll talk about that at another time. Relative to the agenda item, first of all, ministerial process, a lot of people don't have Word on their computer. They don't have the ability to open a Word document. So most of the exhibits that the development services put on the agenda, you can download are in PDF, Adobe PDF, but in I'm looking at 9E, it has the doc one. Yeah, right here, the revised membership list is in Word file. So we need to make sure from a ministerial standpoint that all the documents can be opened up in PDF because people just don't have Word. Word, you have to actually pay, hundreds of dollars to buy the program and they don't have it. So you're going to put something on the agenda online, put it in a PDF format where people can read it. Number two, about this thing that bothered me. What about term limits? We have term limits for the city council. Are there term limits for the P&Z board? Why don't we get some new people on there? I've seen some people been on there a really long time. Am I just haven't seen the term limits? Are there no term limits? If there are not no term limits, why can't they be similar to the term limits that the five of you serve under?
Mr. Chair, that concludes public comments.
Thank you, Madam Clerk. Board members?
Mr. Chair.
Councilman McCoy, go ahead.
Thank you. Mr. Sermons, Mr. Manager, Mr. Attorney, Mr. Mayor. So I see that you guys have been eliminated as ex officio members, and particularly, I know it was very rare that I've ever seen the mayor participate. Well, let me speak to the former mayor participate in the Planning and Zoning Board meeting, but perhaps I could understand why. But in the event that the manager or the city attorney chooses to participate or has good reasons to participate, which I've kind of urged the manager for his attention with, the operations of the planning and zoning board. I guess, why would they not be permitted to do that? And what's your reasoning for removing them from this ordinance?
Mr. Chair, if I may.
Mr. Sermons, go ahead.
Yes, this was one of the minor changes to the language. It was viewed as antiquated language, and it was, to your point, not utilized in any recent history that we are aware of. But if there's a desire for that language to stay, staff has no opposition to it.
See, but here's my problem with it. I've literally watched a number of advisory boards where there should have been an attorney providing guidance and advice to the members of the board. This ordinance, as it already exists, allows for an attorney to participate. What you're essentially doing is removing the attorney from that process. Wouldn't you agree?
Not really. Our legal representation that we have at planning and zoning board meetings is something that we hold to just to ensure that the city is being proper and orderly in the hearings. So we don't view this language as the authority to have legal representation. In the past almost 4 years, there's only been one occasion where there was not an attorney present, and that was not intentional. But otherwise, staff makes a point to ensure either the assistant city attorney or as recently the outside legal support that the city has is present for the planning and zoning board meetings. But that's not the understanding of this language as staff is concerned. But to that point, we can leave it in there just to make sure that there's no lack of clarity to the fact that we do our best to always make sure we have legal support at these meetings.
Okay, well, we can take it out, but I just want some assurances that there's going to be an attorney or some sort of legal guide or advisement at the meeting. I mean, I don't think I need to even go into why I think it's important, but certainly I think we would agree that, members need to have the ability to ask questions of legal nature and be able to get an answer before they deliberate on it. So if you're going to provide or submit to us that there's going to be some sort of legal advice available for the members, then it's fine with coming out unless the manager so chooses to be an ex officio member. I just want to make sure that there's still that legal aspect to the meeting. The next thing is, I think you did great with this item in terms of providing for a law required number of members to constitute a quorum. However, I've not seen how this ordinance addresses the situation of redistricting, which I believe is going to be contemplated to occur before the end of this year. So if you potentially have boundary lines that's going to be changed this year, which probably goes into effect next year, you're potentially going to have a situation where you could have multiple members. I mean, it could potentially skew everything that you're doing and saying each council member gets to appoint a person. So I have a lot of reluctance regarding that part.
Mr. Chair, if I may, to your first point, staff 100% agrees about having legal representation at the meetings, and we are acutely aware of how litigious land development matters are, and even the procedural aspects of the hearing. So we definitely will continue to make sure that we have that at the planning and zoning board meetings. As far as the representation, looking at that section 27-31, I think there's some language that states that each council district shall be represented by one regular member and one alternate member on the planning and zoning board. So I think that if there's a situation where redistricting resulted in there being 6 districts instead of 5, I think that line there would support making sure that additional district is also represented. However, we can amend this language to better contemplate that situation if it occurs, if it's the pleasure of the board. But again, that is a That line in there does state that each council district shall be represented by one regular member and one alternate member.
Follow up, Mr. Chair.
Go ahead.
So Mr.
Councilman.
Simmons, I don't think there's ever a situation that we can expect that redistricting is going to result in a new or creation of a district that's set by charter. But what redistricting would do potentially is if you have one regular member and one alternate member in District 1, if those lines get redrawn, you could potentially have 3 members of the Planning and Zoning Board that literally exist in District 1. So that's what I'm saying. I just don't think this contemplates the fact that boundary lines for redistricting changes every 10 years. And with this new legislation that just occurred in this most recent legislative session, counties and particularly municipalities are prohibited from drawing lines with any kind of consideration of where the candidate, incumbent, or the existing elected official is. So I just don't understand how we're accomplishing that, because you're going to create a situation where that question is going to come up. Well, what happens? Do we attrition the members? And I'm telling you this from experience. There was at one point, the board had 9 members. 7 of them were from District 1, and the remaining were from District 4. And partly because we couldn't get anyone else to participate. So I just think, me personally, I just can appreciate if they came from Peanut Island, if they wanted to participate and they were enthusiastic and, you know, they put in the work. I mean, they can come from really whatever. I just don't think that we need to bound ourselves by saying that you have to have each district having one member and one alternate, one regular and one alternate. I think that's going to restrict it, and it's going to create a problem because nobody knows how redistricting is going to end up. So certainly I don't want to throw rain on it. If you go in and kind of see my position and try to, you know, see what you can work with, I'd be happy with that. I just wanted to make sure I brought that to your attention. That's all I have.
Thank you, Councilman. Go ahead. Board. Madam Clerk.
Councilperson Botel?
Yes.
Mr. Chair.
Councilman McCoy, go ahead.
Mr. Chair, if I may.
I'm sorry, Ms. Evans, go ahead.
One thing that I think the board should consider as it relates to the ex officio, I don't think the mayor's obviously not here, and I don't think he should be excluded from that opportunity, especially when he's not present. That can be something that he still remains as the ex officio member. There's been times where myself and Scott Evans, if there's items with respect to the Planning and Zoning Board staff and the board have been gracious enough to allow for us to have conversations with the board. So I'm not too concerned about the manager or the attorney for that matter being ex officio members, but I think it would be good to still have the mayor serve in that capacity. One of the things to Councilperson McCoy's point that I do want to reiterate is that planning and zoning boards it's a very complicated assignment. And most cases, most government entities have a very hard time filling those vacancies. And it is more so persons that have the wherewithal, the skill set, and the abilities and the desire to want to serve in those capacities. And in most cities, they don't have it where it's based on districts. It's based on qualifications, experience, and a person's ability to serve in that particular capacity. So I do want you to know that it is definitely not common practice where it is district specific. This was staff's attempt to try to address some of the items that were brought forward from the board. But the other side to it is, and I know the board's had conversation, is you don't want a situation where it can conceivably be one person, you know, everybody is in the same neighborhood or lives in the same condo or lives in the same, you know, apartment building or what have you. So those are some things to provide a little bit of context, but that board is a very important board for the city. And so staff took an attempt to try to encapsulate what was discussed at the board, but I did want to provide those bits of comments.
Thank you, Ms. Evans. Pro Tem Lanier, go ahead.
Chair, I just wanted to ask, what does that mean if you don't use districts? How is that determined if you have individuals that, you know, if I say you can apply for the position or another council person says apply for the position, how is it determined that those individuals are either chosen or not chosen? What is the process for that? Because if it's just, you know, non-district, how is it then measured in terms of who gets on the board? Is that something that comes back to us, or is that something that's made at a staff level?
Mr. Chair, if I may,
Mr. Evans, go ahead.
and then I'll defer to Director Sermons. Usually in what most cases is the board is the entity that appoints. So what the application would come in and they would have all their credentials, resumes, experience, or what have you. And then ultimately the board would have the final say on who is the persons or persons that they would appoint. And in most cases, what I've seen in my past experience is they are conscientious of where persons reside as part of the application process. So that's through a process of elimination. And then you all collectively as a board, you may decide that you have two people that are land planners that happen to live a block away from each other. You may say that skill set is valued on the board, and you may want to have more persons from that specific district on that board, or you may want to not have that because they live in close proximity. But that's a policy decision. We'll bring the applications forward, and then you all would make the decision as to who are the persons that would sit in that board if there is no district-specific appointments. And Director Sermons, anything else you wanted to add to that?
No, I'll just further add that in this ordinance, we have added language to be considered for criteria for candidates. We are adding that they must be a resident of the city, which is consistent with just about all of our boards and any other planning and zoning board you would find, but also the types of credentials that are valued, either being knowledgeable in the field of land development and zoning, or knowledgeable about the community or civically engaged in the city, just to provide additional guidance for council to consider when appointments are being made. But yes, as the manager said, ultimately the appointments are made by this body via a vote, so that would not change. But we have oriented it so that each district, it is clear that each district shall be represented by a person on the board to create equity and representation on the planning and zoning board for the whole community. That is the goal of it, but it does not preclude someone from serving for a district if they don't live there. That is not a mandatory requirement, but it is guidance to help us ensure that we spread out the representation.
Chair,
Thank you.
just the
Go
last
ahead.
question. I just wanted to see how you dealt with the issue of term limits. We were having that conversation before about members who've been on the board 10, 12 years. And I don't think there's anything wrong with that, but it does leave a problem with alternates who don't get an opportunity to become full members. So how did you deal with that?
Yes, that is correct. There are no term limits, and we're not proposing term limits in this. And we do believe that there is value in long-serving members with land development. A lot of times it does help to have a long memory of what has transpired land development wise. That can be added, but right now it is not proposed. One of the things we did look to address with this is that the alternate members were not always promoted when there was a vacancy for a voting seat. That's why we have increased the number of alternates and associated them with districts so that if there's a vacancy in the voting seat for District 1, the alternate for District 1 can easily be promoted through that process. And we've added language stating that the board may preference to promote alternates into voting seats as they see fit, whereas there was no language regarding what happens with alternates. Actually, there was no language for alternates at all in the previous ordinance, only a required minimum 7 members. So we think this helps address that, and again, allowing council to, by preference, promote those persons who have been serving already.
Okay, thank you.
Mr. Chair.
Councilwoman Botel, go ahead.
Thank you. In the backup, under Planning and Zoning Board, the document that's titled probably board, city board, just something, I don't know the title of it. It lists a 3-year term. Do we just not abide by that? Is it just not a mandatory 3-year and then you're replaced? Is that just a suggestion?
The terms last for 3 years, but you can be reappointed.
Okay. So there's no term limit. The terms are 3 years, but there's no term limit.
Correct.
Thank you, Dr. Botel. Board members? Councilman McCoy, go ahead.
So you said the board can consider how long a person has been an alternate. You're speaking of the actual board or this council? Because that's very interesting that you said
Sorry,
board.
council.
Okay.
Council.
Has there been a situation, and this is probably one that I would think that probably deserves some exploring, but truthfully, right, once we appoint members, I mean, I don't know that I have any regard to whether a person is a regular or alternate. We should probably consider allowing the board to make that determination themselves. I mean, what's the harm in that? Because truly, right, they keep track of attendance, they keep track of the regular members. If someone was to fall out, why do we need to create another issue, Mr. Evans, where staff now needs to bring that back when you have 2 regular members who are out? Let the board decide to automatically substitute those current alternates into those regular voting positions. I mean, I think that probably makes more sense than to have, staff work on an item to bring it back just to substitute 2 alternate members back into that regular 2 vacancies. Allow the board itself to handle that. That's just something to think about, because I know that in itself was a process that was probably a month and a half at minimum. When a board member leaves, it's a month and a half at a minimum before it gets back on the city council agenda to substitute an alternate into those regular members' slots. So I like the idea that Mr. Evans brought up to keep the mayor on as an ex officio member. So, Mr. Chair, I want to be recognized when we're done with board member comments to include that provision that the mayor should still continue to serve as an ex officio member.
Thank you, Councilman. Board members, any additional comments? Councilman McCoy?
Mr. Chair, I move to include the mayor into the ordinance as an ex officio member.
We have a second? Second. Councilwoman Botel. Additional comments? Madam Clerk? if we can,
Councilperson,
We're going to be disposing of the motion that Councilman McCoy added and then disposing of the item. Councilwoman, I'm sorry, Madam Clerk, go ahead.
Councilperson,
Disposing of it, we're voting on the
I'm sorry,
amendment.
we're voting on the amendment for the item.
Councilperson Botel,
Yes.
Councilperson Mel Anderson,
Yes.
Councilperson McCoy,
Yes.
Chair Pro Tem Lanier,
Yes.
Chairperson Lawson.
Yes.
That vote passes, Mr. Chair, unanimously.
Thank you.
And now we're voting
Madam Clerk,
on
now we have to vote on the item.
Yes, sir. Any further discussion?
No.
Councilperson Botel,
Yes.
Councilperson Mel Anderson,
Yes.
Councilperson McCoy,
Yes.
Chair Pro Tem Lanier,
Yes.
Chair Lawson.
Yes.
That vote passes, Mr. Chair, unanimously.
Thank you, Madam Clerk.
You're welcome, sir.
Item 9D.
Item 9D, ordinance number 4243, an ordinance of the City Council of the City of Riviera Beach, Palm Beach County, Florida, amending Land Development Code, Chapter 31, zoning sections 31-1, 31-61, 31-117, 31-137, 31-141, 31-157, 31-161, 31-177, 31-187, 31-192, 31-222, 31-242, 31-302, 31-322, 31-362, 31-382, 31-422, 31-487, and 31-536, creating sections 31-560, 31-561, 31-562, and 31-563, amending the definition of family, adding definitions for the term assisted living facility, community residence, hospital, nursing homes, recovery community, recovery residence, specialty medical facility, and specialty hospital, providing for severability, repeal of laws in conflict, codification, and for an effective date. Mr. Chair, we do have public comment cards on item 9D. The acceptance of public comment cards for item 9D are now closed.
Motion to approve ordinance number 4243.
Second.
Motion been made and probably seconded. Mr. Evans?
Mr. Chair, members of the board, if I could have the Director of Development Services, Mr. Clarence Sermons, to make this presentation.
Thank you, Mr. Manager. Good evening again, Mr. Chair, City Council. The item before you now is to address some gaps in our land development code as it relates to medical uses and housing for those with certain disabilities. Though the main issue is that many of the uses governing these types of facilities, many of those uses and definitions do not exist in our code, and it has proven to be a big challenge for staff and to regulate such uses. So what we've done with outside legal over the past several months is work to develop a list of criteria, definitions, uses, and regulations, and justifications for all of these uses and how we believe they should operate in the city, and bringing them forth to you for your consideration. For the presentation, I would like to introduce Attorney Tanya Early of Torsivia Donlan Gatto, who has worked closely with staff in developing the ordinance before you. Ms. Early.
Thank you, Mr. Sermons. Honorable Chair, members of the City Council, and city officials, good evening. It's my pleasure to be here and to speak with you about proposed ordinance 4243. I prepared a brief presentation, and I will try to go as quickly as possible to use your time efficiently. So to summarize the changes that have been made to Chapter 31 zoning, we've added all of the definitions that you see on the screen right now. The definition of family existed previously, but it has been updated and amended. And I will note that you did receive a packet containing the proposed ordinance. There will be one change that staff would like to bring forward with regard to the definition of family, and that would be a desire to add a reference to domestic partnerships as defined by the Palm Beach County Code of Ordinances. I won't read the definitions to you, but they were provided in your backup as part of the draft ordinance. And I'll jump right into some of the major changes that you're going to see. And that's going to be a definition of community residences and some of the main characteristics. Now, community residences have been divided into two types per the proposed ordinance. Type 1 has up to 6 residents, and Type 2 has 7 to 14. Both Type 1 and Type 2 residences may have residents that fit under the categories that you see on the screen right now: disabled or frail adults, physically or disabled or handicapped persons as defined by Florida Statutes Chapter 760, persons with mental illness, children, and also persons suffering from addiction. And persons suffering from addiction also not just suffering from addiction, but residing in recovery residences. Excuse me.
I'm sorry, Mr. Chair.
Mr. Councilman McCoy, go ahead.
Thank you. Ms. Early, thank you for that. If you could just take a step back to that previous
Yes, sir.
slide. Let me make sure I understand what I'm looking at, because I don't understand that to be in the code. Are you demonstrating this just for example purposes? Because that's not language that's in this code.
So that language should be in, I will find the subsection for you. It should be listed as just after the preamble.
Right. So I thought we were creating and establishing definitions.
Mr. Chair and council member, if I may.
Please.
So if you look at the backup materials that were provided, the definitions have been added to section 31-1. And there are additional characteristics that are described later in the ordinance. So
If I may, Mr. Chair.
Mr. Sermons, go ahead.
On page 21 of 26, and actually at the very bottom of the page just before that, it gets into the standards for community residences and those listed types of persons that could be included in a type 1 or 2 community residence are listed in the corresponding state statutes.
And thank you, Mr. Sermons, for saving me through paging through all those pages. Those are examples of persons that could live in such residences. There's not a requirement that a resident have any one or any of the above, just to be clear.
Mr. Chair, so
Councilman, go ahead.
what I want to understand, Ms. Early and Mr. Sermons, so is this an exhaustive list? Because you said may include. So certainly, I got a lot of concerns with this, because if someone's operating currently as one of these similarly situated facilities, and we're now here redefining it and saying what characteristics they are, I think, from a procedural process standpoint, we're literally changing almost the use currently of these kind of arrangements that's already existing without really having a seat at the table with them.
So can I address that question in two
Please.
parts, sir? So the first part of this is you asked whether or not this is an exhaustive list. The answer to that is it is not. These are given by way of example, hence the use of the word may. When it comes to establishments that are operating right now, at the time that this ordinance is put in place, to the extent they are non-conforming uses, they would be able to continue to operate as such in accordance with how non-conforming uses are treated within your code. So we're not going to be shutting down anybody, or the ordinance is not proposed shutting down anybody that is legally operating as of today.
Yeah, but if it's not an exhaustive list, it seems like to me that they can always come back in their previous form. I mean, there's a lot of subjectivity to this, because I know specifically, I'm not sure that I can support this, because I know there are members in this community, and then even some that we know that operates facilities. And what I don't want to do is be, I don't want to change. I've not seen, like, you guys have now created and gave us the findings. Absolutely not. Under no circumstances should staff ever make findings for the board. The board makes findings for itself. I mean, that's almost like a judge in a hearing who's required under statute to make findings, and we proffer them up for the judge. I think more or less, I don't think that this is something that I can support, because it's not my interest to protect individuals with a disability as a member of this city council board, because I didn't create this language. And I think when you present this in such a fashion, and I'm speaking of what's on page 20, that's kind of not true. That's not representative of this board. That's not our scope.
Mr. Chair, if I may respond?
Please go ahead.
Okay. Council member, I understand that. What's presented to you is a proposed ordinance for the adoption of the city council. You are the policymakers. The drafter of the ordinance is not the policymaker. So to the extent that you wish to change any of that language where it comes to legislative findings, it is within your purview to do so.
Well, help me understand, why would staff recommend? Is there something greater that we are not aware of as to why it's necessary that we have legislative findings?
So I will tell you, it helps to have legislative findings on the record in the event that the ordinance is ever challenged in court. So especially when it comes to these types of residences, they are typically residences that are occupied by persons with disabilities. And there are limitations that the ADA and the Fair Housing Act will place on the city when it comes to regulating these types of establishments. And so when you have legislative findings on the record, whatever those findings may be, it will help the city in terms of defending any potential challenges. And again, these are presented for your consideration. You are the policymakers.
Right. But these legislative findings seem to be pretty heavy-handed, and I would hope that we would have more opportunity to understand what these findings are. And clearly, what's not indicated here in this ordinance is something that you said regarding the treatment of ADA and fair housing and its applicability. That's not stated anywhere in this ordinance. So what you're saying to me, you're passing me an ordinance and expecting us to adopt it as is, and even to adopt staff's staff's legislative findings when that's not representative of the board. And we haven't even had the opportunity to divulge this information because too often I understand and I recognize that we make decisions based off of what staff put in front of us, but that's really not the legislative intent of this board because I don't know where and how that we we only have two options, yes or no. So I certainly want to give every member, mayor included, the opportunity to understand what this legislative findings means and what the implications are, other than to just vote on a 26-page ordinance with only two options, yes or no. And right now, respectfully, Ms. Early, I'm leaning towards no, because there's a lot of implications. And I can tell you, there are a number of different facilities that's throughout this city, be it drug treatment facilities, being it, what's very interesting is assisted living facilities, even sober homes. But I don't want to go walk into this blindly, more or less, and then have some unintended consequences that come out later because we never hashed out what staff's actual purpose is. And it's like I'm extracting it from you through an interrogation. And I just think we need to have a workshop instead of forcing us to accept some sort of findings. Findings are supposed to be well thought out by the board. And that's supposed to be deliberative, not something that's just brought before us. So members, I just don't know that this is right. I would, we spend a lot of time working on other items, but I can't ever in our time of 4 years here, recall a 26-page ordinance being as massive as this. I mean, the title in itself just tells you this needs time so that we can work on it. So I just can't support this. And I think we have to be prudent and diligent in our efforts to try to make sure we understand and know what's going on here, because this has a lot of implications.
Mr. Chair,
Attorney Nguyen, go ahead.
if I can shed some light, and I don't know if it'll be helpful to Mr. McCoy or not, but maybe it will to the rest of you. If you start initially in the whereas clauses, we talk about the Florida Association of Recovery Residences and their findings and certifications. That's where all of these findings come from. Staff doesn't really have the capability to make findings as it relates to recovery residences, but FAR does. And so as you look through the ordinance and all of the findings, those come from FAR and they're all set out for you. And so basically, when you adopt these findings, you're adopting the findings of the FARR.
Thank you, Attorney Nguyen. Councilman McCoy, go ahead.
Thank you, Ms. Nguyen. I don't even see that in here.
If you look on page 2, Mr. McCoy, the second whereas clause, it's the city council finds that the FARR certifications aid in the standardization and safe operation of recovery residences. And it goes on to clarify what the FAR certifications are. And then as you go over back to the page where you were, section 31-560, it's the city council finds as follows. And it talks about the legitimate public interest in protecting individuals with disabilities, including those recovering from addiction. And if you go down to subsection D there, it also talks about the FARR and their certifications of those facilities. And so that's, again, FARR is the expert agency, if you will, that we get these certifications and findings from. We don't make them ourselves. I mean, we would never, it's delegated to them, to that state, to that agency.
Right, but no member knew about this prior to this other than in the whereas clauses. So FAR can make findings, staff can't, but then you're asking the council to accept those findings.
To adopt the FAR findings, that's what they are.
But see, that's not what we're doing, Ms. Nguyen. We're not
I
just adopting the FAR findings, we're making our own findings.
No, you're not.
Yes, we are. If you go back to the page that I just read, it gave the legislative intent and findings.
If you go to that second whereas clause that I just read, it's—
Yeah, but I'm speaking of the ordinance, the actual ordinance that's going to be codified in Muni Code. The whereas clauses aren't codified in Muni Code, Ms.
They're
Nguyen.
adopted and made as part of the ordinance, yes. They're
No.
incorporated by reference, and
Miss-
that's in section 1 of the recitals.
Ms. Nguyen, when you go to Muni Code currently, there are no whereas clauses. So unless a person actually goes back to the clerk's office and pulls that, but that's not what
That's correct,
Ms.
Mr.
Nguyen?
McCoy, but Muni Code is not the official documentation. It's the codified version of the ordinance, and that's why it doesn't have the whereas clause. The official record is that this document, which will be held in the clerk's office. And you are correct that you won't know what the whereas clauses are unless you go to the clerk's office.
Okay. All right. Well, I just don't think that this is proper for us to take a 26-page document and accept everything as facts and particularly findings. So I just can't support it. And I would ask that we bring this back for a more detailed review, especially considering that, you know, it was brought up that these are connected and then largely due to fair housing and ADA.
Mr. Chair.
Thank you, Councilwoman Botel.
Thank you. I think it's really important that we begin to take a stand about what we will allow and will not allow with regard to sober homes, recovery centers, whatever. And if we're going to abide by the FAR regulations, and this is the way to do that, then I'm in support. But I would like you to explain in very simple layman's terms, what's the benefit to our community of enacting an ordinance like this? What do our citizens get out of this if we say, yes, we want to take this approach? What safeguards will they see as a result of this? I know there's at least one of my residents in the audience who wants to know, how do we control these? Does this, and I think it doesn't, but does this control the proliferation? Or maybe it does control the proliferation. It probably doesn't do anything about the existing ones, but it may control proliferation going forward. And that's the question that I have.
Please go
Mr.
ahead.
Chair, that's exactly well said. Going forward, this will give clear guidance to staff as to where these types of residences can be located within the city and as to the specific standards that apply to them. So right now, you basically have nothing in your code to guide staff. And so that I believe was the goal. Again, I don't want to speak for Mr. Sermons. I don't want to speak for city management. I don't advocate one way or another for this ordinance. It was simply our task to draft it. So I hope that answers your question.
Well, it does, Mr. Chair, if I may. So what you're saying is the benefit to our citizens is that it helps us control the spread of any that don't abide by the FAR requirements, for example. That would be one way that we can help contain the number growing going forward.
Correct. It is an attempt to do that while also recognizing that individuals who reside in these types of places do have,
of course,
disabilities, and we have to be cognizant of that. Right. So it's an attempt to thread that needle.
Okay, thank you.
I did have a question in reference to the resident types. When it says the last line, recovery residence, is that a state registered FAR facility, or what is a recovery residence?
It would be FAR certified, and it is defined in the definitions. So
if the residence is not a FAR certified with a person suffering from addiction, what classification would that fall under?
So if it falls under the category of a community residence and they're operating as such, they must be FAR certified. There's no option for them not to be. If they lose their certification, they will have to, under the way the ordinance is written right now, they will have to stop operating and vacate the premises within 60 days.
And what determination do we set for them to be a community residence? What are the regulations for that?
So if I can continue through
Please.
the next few slides, I can talk a little bit about that. So the key standards for type 1 community residence. The proposed ordinance defines community excuse me. Thank you. The proposed ordinance defines community residence as follows. Community residence means a form of permanent housing for groups that do not meet the definition of family, consisting of persons who by reason of a disability require supervision, assistance, and/or care by supportive staff, and which meet the requirements of Article 4, Section 31,560 of this chapter. So what you see on the screen right now are essentially some of the key standards that are set forth in that article and that Section 31,560. For community residences that have 6 residents or fewer, they are considered type 1. Such establishments must be separated. There are distance requirements. They must be separated by 1,000 feet of when it comes to type 1 community residences and 1,200 feet when it comes to type 2. Again, as I said before, they must be FAR certified. And these are the zoning districts that where they're recommended to be permitted by right. So it's going to be RS6, single family dwelling, RD15, two-family residential, RML12, multifamily dwelling, and RS8, single-family dwelling. A type 2 community residence, again, is that same definition of community residence. However, they're going to have between 7 and 14 people living in that type of establishment. The spacing requirements are more stringent. They must be separated by 1,200 feet from one another and by 1,200 feet from a type 1 residence. They also require FAR certification. And again, going back to the earlier slide, all of these types of persons may live in either a type 1 or type 2. The key distinction is the number of residents. So it's 0 to 6 and 7 to 14. That's the key distinction. Here's your zoning for type 2 community residences. In all of these areas, they are allowed by special exception, whereas type 1 are allowed by permitted as of right. So RML 12, multifamily dwelling, RM 15, multifamily dwelling, RMH 15, multifamily hotel. Now, a third category that we've defined is the recovery community. In the proposed ordinance, a recovery community is defined as follows. Recovery community means a facility consisting of multiple dwelling units in a single multifamily structure that are not held out to the general public for rent or occupancy, that provide a drug-free and alcohol-free living arrangement for people in recovery from drug and/or alcohol addiction, which taken together do not emulate a single biological family and are under the auspices of a single entity or group of related entities. Recovery communities include land uses for which the operator is eligible to apply for certification from the state of Florida. When located in a multifamily structure, a recovery community shall be treated as a multifamily structure under building and fire codes applicable in the city of Riviera Beach. So recovery communities, to summarize, are going to be they're going to be by definition located in multifamily dwelling units. They're going to be run by a single operator, and your residents in such establishments are going to be persons who are trying to live drug-free and alcohol-free. Key standards for recovery communities are on the screen. The maximum occupancy is going to depend on the zoning. They are subject to the 1,200-foot spacing requirement between such establishments. And that 1,200 feet is measured by linear feet from the property line of the nearest existing community residence. They also have to be FAR certified. And again, as with the other type 1 and type 2 residences, if they lose their certification, they have to stop operating within 60 days. The zoning for recovery residences is on the slide. They are allowed by special exception wherever they are allowed, and that's going to be in RM12, multiple family dwelling, RM15, multifamily hotel, RM20, high density multifamily dwelling, and by residential planned unit development. So as far as the planned unit development is concerned, that would have to be something that would be approved at the time that council is approving the PUD. Now, in June of this year, the City Council adopted a new section to Chapter 31 zoning. That's Section 31.9. Section 31.9 allows for reasonable accommodations and is the vehicle by which anyone that doesn't meet any of the criteria that I described before for a Type 1 community residence, for a Type 2 community residence, or for a recovery community, they can go ahead and request a reasonable accommodation if in fact they are suffering from a disability. This is to ensure compliance with ADA and fair housing. In addition to the facilities that I've already discussed, staff identified a need to also define certain establishments that have more intense medical uses that would not be appropriate for a residential areas, and therefore we now have definitions for a specialty medical facility. And that is a facility that offers medical treatment that is just day treatment, no overnight stays. There are special hours that apply, and there are distance requirements. One has to be at least 250 feet away from residential uses. Your zoning classifications are on the slide. And again, they are all in commercial, industrial, community facility, or the downtown general district. For the most part, they would be allowed by special exception. The next is specialty hospitals, which are, as the name would imply, hospitals that are designed for a specific purpose or to treat a specific thing. They are also subject to distance requirements, at least 500 feet from residential uses. Overnight stays are permitted, may be open 24 hours. There's an additional requirement in terms of siting, that they have to be on sites that are of a minimum of 3 acres. They have to have a well-designed traffic flow for emergency vehicles. They have to provide a perimeter security plan at the time of approval, and also outdoor recreation and or passive space for both patients and visitors. Your zoning is, as noted on the slide, again, for the most part allowed by special exception, and in one instance in your downtown general district, permitted by right. Again, you're going to see these in commercial, industrial, community facility, and downtown general district. The last category is hospitals, which believe it or not, although they are listed as a use, there's no change to the zoning as far as hospitals are concerned. I don't believe they were previously defined in the code. Therefore, that was created. And there is a distance requirement of 500 feet from residential uses, and not surprisingly would be open 24 hours a day. And requirements for traffic control and security must be submitted as well. So that is a very, again, very basic overview of what's in the ordinance. I do understand that it is a very long ordinance, and there's a lot for council to consider. So to the extent I can answer any more of your questions today, I'd be happy to do so.
Mr. Chair.
Let Councilwoman Lanier go, and then Councilman Botel.
Mr. Chair, if I may. Mr. Chair, if I may add one more thing before you go into questioning, I would like to note that the second reading for this wouldn't be at least until a month from now. So there is time between now and second reading to digest this due to our calendar. So any concerns about the length of it, I just wanted to note that for the council as well.
Thank you, Mr. Simmons. Pro Temp Lanier, go ahead.
Yeah, I think that this is something that we've actually been looking for. We've had conversations in the past numerous times in regards to the proliferation of sober housing and proliferation of these types of facilities. I think that we need something that is going to safeguard the community, but also welcome those type of businesses, but also make sure it protects the community. I know that the conversation that we did have was in regard to how the city of Lake Worth Beach got inundated with sober housing. and had to kind of catch up their code to be able to kind of regulate them. So I really appreciate the work that has gone into making sure that we cover all the bases in regards to how we are looking at these types of facilities in the city of Riviera Beach, and that we're not trying to dissuade them from being here, but also to welcome them and regulate how they are and how they appear in our community.
Thank you, Pro Tem. Councilwoman Botel.
Thank you. Do you have the ability to pull up the map that we looked at in our agenda review?
I think
And
maybe
my
Walter is on it.
And I guess I have a couple of questions about, in our agenda review, I think I might have asked for, and you'll see it when you pull up the map, it's very difficult to actually see where the facilities are on the island because they're so densely clustered. And I wondered if I could have a list of the addresses of those, because people frequently ask me, oh, there's a sober home in our neighborhood and the guys are hanging out outside, et cetera. And I want to be sure that people are actually identifying real, legitimate sober homes and not just somebody's house that they've let out as an Airbnb and there's some people hanging around there that maybe are up to no good. So it would be important for me to know where exactly they are. And it's difficult to see on the map in the backup. And if you can pull that up, I'll show you. And also, when you look at the map, you can see, and he's getting there. When you look at the map, you can see the overlap, and particularly on the island, also on the mainland, I think, but especially on the island, the overlap where they're much, much more densely clustered. As we've said, people like to be on the beach, whether you're trying to recover from addiction or just trying to enjoy the beach. You like to be near the beach, so I can understand why they're there. But nevertheless, it seems like there are so many of them. Can we not? I guess my question is, can we not do anything about the ones that are there already, particularly in the cases where they seem to be bothering the neighbors a lot? I mean, does that come into code compliance? Does that come into policing? How do we deal with the sober homes that are there and are causing a nuisance in the neighborhoods? There. Look at the island. It's I can't even count how many blue stars there are in the middle. Never mind the red stars down to the south, which is the ones I think right on Blue Heron. It's almost impossible to tell how many there are because it's so dense.
If I may, Mr. Chair.
Please, Mr. Servants.
And one of the challenges with this is that we didn't have definitions for the different types of uses, but the circles and the blue circles, the red circles, and the yellow dots indicate different types of uses. And most of them, except one, we did not have defined in our code. So sober homes, to your example, is not language that was previously in our code. We had to utilize our partnership with the police department and the calls that they respond to best identify where these operations are, because they are not legally approvable in the city right now. So this ordinance would, again, give a title to it and give standards to those uses so that moving forward, if one of those businesses comes forward to establish itself or get its business tax receipt, we will have the zoning and licensing and other standards and requirements that we can evaluate them against. So to that question, those blue dots are in most cases are not established as sober homes or recovery residences as this ordinance would describe them in the city right now. So those are things that we moving forward would look at.
Okay, but so I guess if I may, Mr. Chair. So what I'm saying is there's no way to retroactively say we don't want that one or that one or that one. They're there, they have to stay there, and only if they were to come to the city to get a business tax receipt, and at that point we can say we can regulate them?
Mr. Chair, Madam Council Member, so there are legal concerns when it comes to lawfully, the key is lawfully operating establishments and applying zoning codes retroactively. To the extent one of these establishments is operating, though, they should be getting a BTR. And when they come for the BTR, I would think at that time it would be incumbent upon staff to determine whether or not they're properly certified. So they're still going to have to be certified going forward. However, to the extent they don't meet the distance requirements right now, if they're otherwise lawfully operating, I think there would be issues applying that retroactively. So that would be my short answer. It's going to kind of be case by case, depending on how the establishment is operating, whether or not they are, if they're doing other things that violate your code, they're not immune from code enforcement either.
So it really becomes an issue of policing rather than, or code enforcement or policing if the place is unsightly, whatever, if it's overgrown, that's code enforcement. But the issue of people hanging out outside smoking dope, that's policing. There's nothing we can do about changing. If they exist already, we can't do anything about prohibiting them from doing business.
That, Mr. Chair, Madam Council Member, that would not be lawful.
Okay.
In most cases, that would not be lawful, and it would be a law enforcement issue.
Okay. But I do need a list of the addresses, just so that I can tell people, hey, you may be complaining about something that you think is a sober home, but is actually just somebody's Airbnb, and, it's not really a sober home. So that would be helpful. Thank you very much. Thank you, Mr. Chair.
Thank you. Board members? Councilman McCoy, go ahead.
So, Ms. Early, Mr. Sermons, so am I correct in understanding that Florida Association of Recovery Residences regulate, or in other words, certifies sober homes and assisted living facilities?
So that's the FAR certification is specific to sober homes. I'm going to say sober homes, but they're not defined as such in the proposed ordinance. They're actually defined as recovery residences and recovery communities. So FAR regulates those to the extent that they provide a voluntary certification. This code goes above and beyond that by saying that you have to obtain that certification in order to operate in the city. Nursing homes and assisted living facilities, to the extent they are operated by the state, would fall under a different category or a different statute. And again, they still have to have all of their proper certification from the state in order to operate. So it's not just the FAR certification that's required. If there's anything else that the state of Florida requires an organization to have in order to operate as such, they need to have it under the code the way that it is drafted at this time. Otherwise, they may cease operations.
Okay, so just let me make sure I understand this, because you gave me more than I asked for.
Okay.
So FAR is a voluntary certification, but we're going to require as a requirement that they go and register for something that's voluntary.
That is the way the code is written, yes.
That's really hard to make sense of. It really is. So we're exceeding the voluntary requirement to make it a mandatory requirement to be registered, or to be certified, I should say.
Yes, that is correct. It is, there are multiple examples, and I will start with saying that we would not be the first city to do so. We studied multiple municipalities and their regulations regarding these uses to develop this code. So we would not be the first city to require this. But to the second part of your question, there are numerous cases and instances where these types of operations have not been managed well. And
Okay,
it's
but all right, let's stop right there. Let's stop.
Okay.
I just want to, I'm trying to get to understanding, and you're talking about whether they've been managed correctly. So if I can understand this correctly, we're requiring mandatory registration, which is otherwise voluntary. And you'd say yes. However, my next question is very simple. So if that is the case, this doesn't even affect those that are currently existing, only those that become legally, I guess, that go out of it conformance. Is that correct? So this is only going prospectively.
I would interpret the certification as something that's going to have to be an ongoing
But
requirement.
my question is, if there's a sober home or recovery residence or recovery community that's already existing within the city of Riviera Beach, this ordinance has no effect on them unless they become not operable.
So
And it's either yes or no, Ms. Early. I'm just trying to get to a point of clarification, and I don't want a dissertation.
So, Mr. Chair, again,
Please.
I believe the certification.
This is why a workshop is necessary. I mean, like, are we regulating those that are currently existing, or is this going to be for new recovery residences?
The way that I'm reading the ordinance as proposed, in order to get a BTR and continue operations, existing establishments would have to get certification. Of course, if it is the pleasure of this council not to have that requirement apply, you can certainly, between first and second reading, direct staff.
All right. Thank you. Thank you. I reclaim my time. I don't know why it's so difficult to get a very straight answer. And it seems that staff doesn't know. And if it's your intent, which you certainly have a prerogative to propose whatever it is that you want the board to consider. But if it's your intent that this goes into effect upon adoption, that every sober home or recovery residence in the city has to now be certified with FAR, then I think it should just be plainly stated. I'm okay with regulations and governance. I want full disclosure though, and it seems like I'm squeezing to get a straight, what should be a yes or no answer, which lead me to believe that this is not really fully cooked, and you guys can't even plainly and clearly say the applicability of it. I mean, help me out. I mean, what the decisions that we make, Ms. Early, thank you. This is the first time that you got to experience, Mr. McCoy, but like, we make decisions that determine whether people live and die. So if you're going to present something to me, I just want to know, what kind of scrutiny I'm going to have to deal with when I go out to the grocery store, because now I've just voted on something that's changed someone's total livelihood, and whether it goes into effect currently or only for new businesses or new recovery residences. That's all I'm just trying to get clarity on. And then, I've raised my white flag because I just give up. It seems like it's just hard to get a plain answer. That's why I can't support this, Mr. Chair.
Thank you, Councilman. And I would agree that I just think we need to have more discussion and just a little bit more dialogue and understanding. I do want to understand, though, what is the definition of a sober home based upon this ordinance?
So the ordinance does not use the phrase sober home. It would be a recovery residence as defined in the ordinance, or in the case of one that's located in a multifamily structure, a recovery community.
So under a type 1, 6 residence or less is a recovery residence. And then that would require a 6 residence or less that is in a recovery residence. And I just want, I guess, clarity, layman's terms, as to what a recovery residence, because the scenario would be if I brought in a friend of the family and his wife who's suffering or struggling with recovery, would now my household be considered a recovery residence because I've taken in these 2 individuals?
Mr. Chair, recovery residence is more than 3. So if you're taking 2, then no.
Does it say that in FAR
Yes.
definitions?
Yes.
But I guess I would agree with Councilman McCoy that it is a voluntary legislation with FAR versus what we'd be enacting, which is a mandatory policy would be setting. And I'm a little concerned based upon ADA and Fair Housing Act, and also understanding a little bit about the sober home community, that we have to be very cautious with how we actually regulate and what we put into this ordinance. And I think that we just want to understand a little bit more and go a little bit more in depth. So I couldn't support it currently, and I wouldn't actually wait for second reading. I would want us to hold off on that, is my personal opinion, to just get some more insight. This was a discussion I had today. And that's my issue. And it's not that we want to kick this can down the road, but it's been a discussion, as my colleague said, that we want to address and take a firm stance on. But I also want to get it right. But go ahead, ma'am.
Mr. Chair, I completely understand. And to the extent that you wanted to workshop this, I understand that too. This is a lot that's being presented before council. As far as recovery residences are concerned, yes, the code does have a definition, as Ms. Nguyen pointed out. that refers to, it's a type of community residence that provides lodging for more than 3 unrelated persons suffering from addiction, occupying the whole or part of a dwelling as a single housekeeping unit, sharing common living, sleeping, cooking, and/or eating facilities. So I understand your concern that informal types of arrangements might somehow inadvertently fall into this category. But I'll repeat what I said at the beginning, and at the risk of sounding like a broken record, you are the policymakers. So if there's anything in this document that you don't like, it is within your purview to change it. And I do think
Chair.
that it,
Councilman McCoy?
I just want to respond as soon as she finishes.
Thank you, sir.
I do see, after having discussion and hearing feedback from council, it's clear that we need to add a subsection specifically addressing non-conforming uses, and we specifically need the guidance of the board as far as how you want those to be handled. If you don't want the certification requirement to apply retroactively, that can be written into the ordinance.
Okay. Councilman McCoy, go ahead.
Well, thank you, for Ms. Early, for that. But, you know, I would agree. You keep insisting that we're the policymakers. In fact, I don't think nobody up here would dispute that. We were sworn in. But you know what that tells me? You're literally giving us the biggest piece of legislation that we've ever worked on and saying, we're the policymakers. You guys decide what you want to keep and what you want to get rid of. That's what I'm understanding, because you said it maybe 3 times at least. And not only that, I'm looking at, I think this is page 4 of the ordinance. I've never, ever in my life seen this in terms of state statute. Ms. Wynn, if I can have your attention on this, as well as in local. I've never seen in my life any piece of legislation that ever referenced unmodified portions of section have been excluded for brevity. That doesn't make sense whatsoever to me. I've not ever seen that. And it's underlined to suggest that this is going to be added into the actual final language. So if for the intent, this is much larger than it really is. The document is really more than 26 pages, because clearly we've left off portions that have not been modified. But certainly, if we're the policymakers, give us the full clip. Don't give me just a portion of it. This is no way proper. And I just am afraid that if we adopt this, I can already see it now. The other thing that came to mind is we had a property swap, Mr. Jonathan Evans, with this gentleman with the expectation of going out in the industrial area on the corner of MLK and Military Trail. And specifically on those slides, that zoning district was not called out. That zoning district called for a special exception. There are very strict standards to a special exception, Mr. Evans. I mean, we in good faith entered into which should have been a fee simple deal with the expectation that he was going to be able to build a facility on there. We could not guarantee him approval. And I think there was a whole conversation about giving him preliminary site plan approval. But now with these new zoning regulations, that could very well tank his whole plan of, you know, developing that property and opening up. I think it may have been even a recovery residence that he's contemplating there, because that zoning district wasn't even called out. And if it was, it's under special exception only. So there's a lot of implications with this, and I just don't know that we're ready to have a discussion on it. I can't think of any other piece of legislation or policy ordinance that's been this big since we've been here, and this is very detailed. And I don't want the responsibility of being able to only have 2 options, and that's a yes or no, and being asked to do it in such a short meeting. That's all I have, Mr. Chair. Thank you.
Councilman. Board, can we go into public comments and then continue with the discussion? We have 2 comment cards. Thank you.
Ms. Paige Parker and Ms. Cindy March.
Thank you.
Good evening. So this is a very, very important matter, and I have very specific experience with this. I am fortunate enough to have been a property owner in Riviera Beach for 28 years. I worked very hard at a very young age and am a proud resident, proud property owner for over 28 years. Unfortunately, almost half of those years were spent living across the street from a gentleman that ran a sober home with no regulation. It was very sad. It was sad for the residents in that facility that were trying to get help, that were promised help. It was sad for the neighbors who were exposed to the emotional toll of watching a beautiful home go into disrepair, watching ambulances come, taking people away that have OD'd, just watching drug dealers come into the neighborhood, so obvious. And it's happening. Everyone knows what's going on Singer Island. Everyone knows what's going on Singer Island specifically. These sober homes, these treatment facilities, they come in, they sell the dream. Bring us your insurance, bring us your loved ones. We're going to take them to the beach. We're going to do yoga. We're going to go paddle boarding. It's going to be great. Well, I'm sure you've all seen the Palm Beach Post article that was on September 24th about this poor child, this poor young man. And I'm sorry to be blunt, Mr. McCoy. You want to go to the grocery store? This poor man rotted in the bushes at Publix from one of the sober homes that kicked him out. He went over the bridge, bought drugs on Broadway, did his drugs, died in the bushes, sat there and rotted for 4 months. So when you say about going to the grocery store or whatever your comment was, and about having mandatory requirements, why wouldn't they want to say, hey, yes, I took that certification. Yes, we pass all these regulations. Why wouldn't they? As a business owner, I sign up for every course there is, every regulation. I want to be the shining star. I will be the first one. I don't care if it's voluntary or mandatory. If it's a guideline that's going to make me look more responsible as a business owner, I'm all for it. Why not? So please, I ask that you give this serious consideration and don't be fooled by the ADA regulations. They are there for a certain specific reason, and these certain owners, most of them that I have dealt with in my 28 years of being a property owner, they know how to hide behind the ADA. They know the loopholes. They are good at it. They make a lot of money. Talk to Ehrenberg about his task force on this. Read this. I'll leave it for you. Please give this a lot of attention and as soon as possible.
Thank you for your comments, Ms. Page.
Thank you.
Ms. Cindy March.
Welcome, Ms. March.
Hi. Good evening, council. We do need a facility for mental illness and sober people. But let me tell you something. Every time we say put something on Singer Island, it always got to be a problem by lifting up somebody's nice little peaceful home. But y'all don't think twice when you want to put fire stations on the west side of town, not just one or two. We hear the same noise that Singer Island here. This is one city, and we need to start treating it like one city. I'm all for mental illness because I was once one of them. I am one, but you got to do it the right way. I'm 100% with Sergeant McCoy. I will say it over again. You might not like his demeanor, but he tells the truth, and he gets all the loopholes the way they need to be done. You all need to stop letting these people come up here and dictate what they want to do with our city. We hired you all by voting for you all. We want you all to represent us as citizens of Riviera Beach. If you do for one part of the city, do for the whole part of the city. Every time they want something on Singer Island, oh, it's going to lift up their home. You got drug dealers everywhere, not just on the west side of town. It's more dope dealers on Singer Island without the sober homes. So whatever these people want, I'm not saying give it to them, but they can't come in here with that old half writing and half information and misleading people. Good thing we have Sergeant McCoy. We need a few more Sergeant McCoy on this board to understand the terminology, what these people provide in front of us that we don't know, because enough is enough.
Thank you for coming, Ms. March. Pro Temp Lanier, go ahead.
Yeah, I just wanted to say that I certainly support this item. I also have a personal story about where I live in Federal Gardens and have had to deal with these type of facilities that have not been regulated for years. I had my neighbor, which was a previous council person, Liz Wade, would call me all the time asking about the property across the street. But don't get me wrong, these are some of the programming that we need for the city of Riviera Beach in terms of mental health, in terms of addiction, but it has to be regulated. And I'm afraid that if we pass this opportunity up to be able to do that, then it appears that we are not serious about it. And also, you know, when you're having conversations about the language that's in it, you know, you speak to people in a certain manner, you respect people, you are able to disagree with them without badgering them or demeaning them. So I just really want to know that we have a opportunity here to voice our concerns, to be able to talk to people like they're human beings, to be able to disagree respectfully, but also to make sure that we're looking at all the pieces of this. But I certainly, because of my personal history with this, and just not just in front of my house, but in my neighborhood, these things are not regulated. And I'm afraid that if we do not regulate them, then we will be just like Lake Worth Beach, trying to catch up to our ordinances to regulate these type of properties here in the city of Riviera Beach. And I think that we need them, but we also need to regulate them.
Thank you, Pro Tem Lanier. Additional comments from the board?
Yes, Mr. Chair.
Councilwoman Botel, go ahead.
I'm in favor of moving forward on this evening, given that we know we have at least a month before the next reading will take place. It would seem to me that's plenty of time for us to ask any questions, modify this in any way we see fit, have a workshop if that's what the majority of the board thinks we need, but let's get moving on something. We now have nothing. We have nothing that regulates them in the way that we feel they should be regulated. I think they all should abide by the FAR standards. I mean, it's about time we set some standards forward for people to abide by. So I'm in favor of moving forward tonight and then making any changes we see fit before the next reading.
Thank you, Councilwoman Botel. Councilman McCoy, go ahead.
Mr. Chair, I wanted to revisit the item Ms. Early first mentioned about expanding the definition of family to include domestic partnerships. If we don't have any other comments, Mr. Chair, I want to be recognized to offer an amendment to include that.
Thank you, Councilman. Councilwoman Miller Anderson or any other board members? No?
I'm in support of it because, you know, this has been something that we've needed for a while. Many people have complained about it not being regulated. So now that we have something, I do think we need to move forward. And like Dr. Botel said, if there's anything that we need to do to correct anything or fix anything or modify anything, we have time to do so. So I'm ready to move forward.
Thank you. Councilman McCoy, go ahead. I'm sorry. Councilman, you making your motion or can I just take
I was going to make a statement.
Okay, go ahead, Councilman McCoy.
I'm okay with that. To my colleague, Miller Anderson, I'm okay with that. But don't you think as policymakers, which Ms. Early specifically referred to us at least 3 times, that if I ask a question as to the applicability between Ms. Early, Mr. Sermons, perhaps even our legal, someone should be able to address when this applies and is it applicable prospectively? I mean, that's a fundamental question that we should be able to ask. And for any member, that should create some unreadiness if staff is not even certain. So I certainly believe in regulating, but I certainly have a lot of reservations if staff is not even 100% certain and they're shifting the burden on to us and we only have 2 options. That's either yes or no. And I'm okay with addressing it, but I mean, board members, we see too often that we deal now with problems from previous councils because of their failure to act. And in many cases, they acted and probably they did not explore all of the options. So certainly that's all I'm asking, that we be very thorough in our work here. So, Mr. Chair, whenever you're done with, I would like to offer up that amendment.
Thank you, Councilman. Pro Temp Lanier, please go ahead, and then Councilwoman.
I just wanted to say quickly that we need to, this is the most important part of this. These regulations are here to protect the people who are in these facilities. It is about them. It is about people who are having issues with addiction, mental health, and having a place to go that is regulated, that protects them as the client, as the human being. So we need to make sure that when we look at these type of facilities, that we are regulating them based on the fact that we are making sure that people who come to these facilities are protected.
Just to those comments, I agree. Understanding that I'll be working with outside legal with Mr. Sermons just to discuss it between the first and second reading, because as Ms. Miller Anderson stated, I want us to make sure we get this right. We do need to protect these residents, but we also do want to make it restrictive to where we're not giving them support that they need, and just get it right the first time. And I actually agree with all my colleagues' concerns. So I appreciate the constructive criticism and the healthy debate and discussion. So if we can move forward, I would allow for staff to set up a time. Mr. Evans, if you can set a time for us to have this addressed, whether it's a discussion item, workshop, or just individual one-on-ones to further go into detail, I think that gives us an opportunity to really dissect this before our next meeting where this will be presented to us. Councilman McCoy, if you want to go ahead with your amendment, please.
Mr. Chair,
Councilman, go ahead.
I want to amend this ordinance to include in the definition of family domestic partnerships.
Do we have a second for that?
Second.
Motion been made and properly seconded. Any discussion?
Excuse me, if I could.
I'm
just
sorry,
for
go
some
ahead, Attorney Nguyen,
clarification.
please.
Mr. McCoy, we took into consideration the comments that you made at your agenda review, and the language will say domestic, included in the definition of family is domestic partnerships as defined in the Palm Beach County ordinance.
Okay, so does that mean I don't need to do the?
So is that
No, I'm just letting you know that that is the way it will read.
okay? So when it comes
Oh, yeah,
back for
most definitely. I would agree. No other way. I mean, I think, somebody can have a domestic partner every week, more or less. So certainly it has to be one that is actually registered as provided in Palm Beach County ordinances. Yes,
Okay.
yes, ma'am. That's perfect.
Thank you.
discussion, Madam Clerk, if we can vote on the amendment.
Yes. Councilperson Botel?
Yes.
Councilperson Miller Anderson?
Yes.
Councilperson McCoy?
Yes.
Chair Pro Tem Lanier?
Yes.
Chairperson Lawson?
Yes.
That vote passes, Mr. Chair, unanimously.
Thank you, Madam Clerk. And can we vote on the ordinance, please?
Mr. Chair,
Attorney Nguyen.
if I might, I know you requested a workshop or something between now and second reading. You may want to just give it some thought. You can tell us now if you want, or just at whatever the discussion item is going to be, whether or not you want to grandfather in those that already exist in the city so that they don't have to comply with the FAR requirements, that would be my recommendation, and that you do it require the FAR registration prospectively.
Mr. Chair,
Councilwoman Botel.
could I just ask why?
Number one, I don't think that it may not be legally defensible to put a new requirement on those already existing. That's the main reason.
Yeah, I know. I wanted to say that I thought that when she talked about registration or registering this business in the city, that they would have to provide that then. That
New businesses, correct.
new businesses, right? But if the person had to come back for recertification and was not under those auspices of FAR, then they would have to, at the time of their renewal, to do that.
So I'll give you an example. Let's say there was a recovery residence already existing, and then for some reason they became non-conforming, or they went out of business for a certain period of time, or their BTR lapsed and they had to come back and recertify. Then the new requirements would kick in. However, if you have a current recovery residence and they never go out of non-compliance, they're always conforming, they never had FAR before because we didn't require it, you still wouldn't require it now.
That was my understanding of what she said. So, yeah.
Additional comments from the board? So Attorney Nguyen, that would be part of the discussion, whether it's workshopped or we do one-on-ones or have this as a discussion item on the next agenda. Thank you. Madam Clerk?
Councilperson Botel?
Yes.
Councilperson Miller Anderson?
Yes.
Councilperson McCoy?
No.
Chair Pro Tem Lanier?
Yes.
Chairperson Lawson?
No.
That vote passes, Mr. Chair, with both Councilperson McCoy and Chairperson Lawson dissenting.
Thank you, Madam Clerk. We're going to go into public comments. Residents, if you have any public comment cards, please submit them now. Public comments shall begin at 7:30 unless there's no further business of the City Council, which it shall begin sooner. In addition, if an item is being considered at 7:30, then comments of the public shall begin immediately after that item has concluded. Please be reminded the City Council's board has adopted rules of decorum governing public comment during the official meetings, which has been posted at the front desk. In an effort to preserve order, if there's any rules not adhered to, the city council chair may have any disruptive speaker or attendee removed from the podium, from the meeting, or the building. Please govern yourselves accordingly. Madam Clerk, public comments?
Mr. Chair, we're going to call Mr. Eric Ward.
Welcome, Mr. Ward.
Thank you. Hi, I'm Eric Ward. I've been a resident of Riviera Beach since 1985. A few months ago, I spoke here about the flooding on Doral Way in Lone Pine, and I had talked about how the fire hydrant in our across the street has a couple times been submerged in water, although usually it only gets maybe halfway up. After that meeting, one of the city engineers came up to me and said that that had been fixed decades ago. I told him that still every 5 to 8 years or so, maybe it doesn't get all the way to the top, but it goes like halfway up the fire hydrant. But he didn't believe me at the time. Anyway, this last Sunday's flood may not have been the deepest one that we've had there, but it was different from the previous ones. The water was 17 inches deep at the fire hydrant, which I have a picture of here, almost to the top. And that was 17 inches at the fire hydrant, about 20 inches actually at the storm drain, which is really just a few feet away from it. There's two by 4 foot storm drains across the street from each other there. With 2 feet of water over them, there should be a torrent of water going in there, as I said previously. Last time I mentioned there was just a gentle flow of water going in. What was different this time is that it started with the gentle flow, but as the water got higher and higher, it slowed down to the point where the flow was imperceptible. And I have a picture here that shows the storm drain, and it's clear there's no debris blocking it, but there's no flow at all that you can see in the picture or that I could feel standing in the water there. What that shows is that the canal level is too high. The canal level is only a couple feet below the street. You know, if you look in the pipe, you never could see the bottom of the pipe. The water is always just a few feet down. So now the water level was several feet above the street level. It means that the canals just can't handle this much runoff. The issue with the proposed neighborhood now coming in, which should have been a moot thing, but seems to not want to go away, they're now talking about taking this area where the water seeps into the ground, raising the area up higher, paving over a big portion of it, and then catching that water and funneling it with their own direct pipes into the canals, giving them preferential access to the canal, and therefore raising the level more to slow down our water coming in. So it really shouldn't be done that way. You know, they shouldn't be coming in at all, but if so, not like that.
Thank you for your comments, Mr. Ward.
Thank you. I have these pictures if anyone wants to see them.
Mr. Ward, if you could just leave them with the clerk, she'll hand it out to the board. Just leave it with the clerk or give it to Chris here, either one. Thank
Mr. Bill Walatich. Miss.
Good evening, everybody. Can you hear me all right?
We can, Mr.
Yeah,
Bill.
okay.
Welcome.
I attended the D.R. Horton meeting last night in regards to the Lone Pine Golf Course. But what follows on what I'm going to say can possibly apply to other properties in Riviera Beach. We got the same sales pitch about the golf course. D.R. Horton's attorney claims that if we don't go with their plan for development, any builder, not D.R. Horton, will build according to Live Local and cannot be stopped. D.R. Horton is claiming that they have a better plan for development. In other words, D.R. Horton is trying to get the residents of Lone Pine to side with them to rezone the golf course. The Live Local law does not, in the entire document, state that the land zoned recreational is eligible under Live Local. If I understand D.R. Horton's attorney correctly, they are claiming the following. Since the golf course property owner has a commercial license to run a business, the land is commercial and thus allowing the development according to Live Local. Again, the Live Local law does not in the entire document state that land zoned recreational is eligible under Live Local. Their interpretation is inserting the word recreation into the law. This is their interpretation of the law. I'll bet we can get many other different interpretations from other attorneys that would say something completely different. What concerns me the most is how the council will react to the Live Local law according to D.R. Horton. Before anything continues, the council should have a clear understanding of the law, definitions, and an accurate interpretation. If you go along with one interpretation of the law, this opens up a can of worms for other developers to define Live Local their way and start developing without any interference from the local government. If you can get clarification from the state, this would solve the major issue of interpretation. By letting one non-state entity's interpretation dictate Live Local is letting the developer run the city, not the elected officials who represent the constituents. Think about that. Another Live Local issue came up and another interpretation is submitted, and this can go on with no concise definition. This is why it is important for the council and other city officials to get direct interpretation from the state. This way, there will be a clear understanding of the law and eliminate interpretation guesswork. If the D.R. Horton interpretation is here to and development starts and the state comes back and says that D.R. Horton's interpretation is incorrect, probably too late to stop the development. By this premise, you could see the issues this would cause in the community. Development would start that would be completely wrong. As I stated previously at all other meetings, develop the real estate that is already zoned in accordance with the Live Local. Isn't this what Live Local is all about? Thank you. And
Thank you.
sorry I went over.
Thank you, sir.
Mr. Chair, Mr. Grayan Laguerre has pulled his card.
Thank you.
Ms. Rochelle Baker Hughes and Ms. Annette Dragon.
Welcome, Ms. Hughes.
Good evening. First off, I want to thank the following. Ms. Lanier, who's not here, Ms. Botel, Mr. McCoy, Mr. Lawson, Ms. Deirdre Jacobs, for the ribbon cutting this past Saturday at Lone Pine Park. It was great, and I got to tell you, I had the most fun with the animals, with the petting zoo. So thank you very much for that. Going from that, as we were at the Lone Pine Park doing this, we noticed all the standing water. And we also told the officials, drive around our neighborhood because there's a lot. We get it. There was rain. However, Saturday evening, my husband went outside and he was about knee deep in water in front of our house. Sunday morning, he called me and said, "Have you been out in front of our house?" And I said, "Nope." He goes, "You better come out." I was knee deep in water and he couldn't get home. He had to park somewhere else to carry the groceries home. Sunday late afternoon, same thing. We have a drainage issue. As we have said over and over again, we have a drainage issue. And we need to do something about it because the standing water that it was, and I will tell you, my neighbors 2 doors down were coming home. They had 3 children with them, 3 adults. And one of those children has a disability. And I walked over to Lockmore and I walked to meet them and I told them walk down the middle, even though the water was still probably shin high, just so that they didn't walk down the sidewalks because you really couldn't pass them. So we do have a drainage issue that needs to be addressed. I have contacted Ms. Jacobs, who has been so kind to respond back to me with stuff. So then you get to the golf course, and I'll do this really fast. That golf course cannot have any development of any kind to lose the grass that we have and everything, because it would have to be built up higher than us, cement. Guess where all that water is going to go? into us. And it's going to be worse than what Mr. Ward pointed out and what any of us, we all have pictures. I think you've all been inundated with pictures, if I'm correct. So yeah, we do have a drainage issue that I hope we all can get together. I don't care if we have a committee to discuss the drainage issues, but we do have drainage issues. Thank you.
Thank you for coming to Speaker Hughes.
Ms. Annette Dragon, and then Mr. Lloyd Brown.
Thank you. Welcome, ma'am.
Hello, everyone. I'm going to echo what Rocky just said about the event at Lone Pine last Saturday. It was delightful. Thank you all for coming out. Also, thanks to Richard Blankenship, who actually spent a lot of time making it happen for our park. Going on from what Bill, my husband, said and what Rocky has just said, this drainage system is ridiculous. It's based on an arcane system of measurement that was developed 50, 60, 70 years ago or more. It obviously needs revamping, rebuilding, and looked at. And I would suggest that the city manager, the public works manager, the city engineer, and council appropriate some funds to actually revamp the entire system before they even look at putting any new development anywhere in the Lone Pine area, or in fact anywhere in Riviera Beach, which has been suffering the same kind of drainage issues all over. I've read a whole lot of stuff about this on the Nextdoor website. I've seen stuff on the news. I hear stuff in the street when I'm out. And on top of that, I run every day in our neighborhood. And I've noticed that as a result of this severe rain that we've had over the last few days, that some of the roadway has actually started lifting. Now, whether that's due to burst pipes from the drainage system or anything else, I don't know, but it really needs looking at. Please do something to protect our community and the drainage system.
Thank you for your comments, ma'am.
Mr. Chair, before Mr. Brown makes his comments, let the record reflect that Ms. Lanier left at 8:07 and returned at 8:14.
Thank you.
You're welcome, sir.
Welcome, Mr. Brown.
My name is Lloyd Brown. I don't apologize for the first time I came up here. So don't look for no apology. And I'm just here right now because, you know, I see that the city, like the Public Works Department, and subbed out 8th Street, you know, so like all them young kids who don't have no skills and could do those jobs, you know, you done subbed it out to a guy that, I'm going to say ninja. I'm not going to say the word he said, but he said that he's a rich ninja. He don't care nothing about them poor ninjas. So you know what I'm trying to say. I'm not going to say the N-word, but that's what I mean. Same guy that you got over there, subcontracting, and it look different. I ride that way every day. And you know what? They doing a terrible job over there. You should have left Public Works in there because they can hire more kids in the neighborhood who don't have skills, who can't go to college playing basketball, who don't have education in their head, you know, to do something else besides manual labor. Why would you subcontract out something when you said these people on 13th Street, they hired these people in, then you go subcontract out 8th Street, and then you subcontract out S Avenue. And you know, you got all them people that go to that park on S Avenue. A lot of those kids, they can't do anything, you know, like mathematically in school or whatever. They're not really smart, but they can do labor. But see, y'all seem like y'all don't care. You subbing it out to some people who won't even come in the neighborhood. It's the same thing with the churches. The churches, they get people to do jobs when they got their congregation that can do these jobs, and they'll hire somebody else, and these people don't even come to that church. They won't even show up. And you got your congregation that's got kids who probably don't make it through school, and even if they get in trouble, you give them an option. Say, well, you know, we're going to try to find you a job. Just go ahead on, you know, because now in school, I think all you got to do is be there. You don't have to have, don't have to make, you know, no A's or B's, just showing up. And I think the city, it's your obligation to make sure that these young kids, I'm talking about not me, I mean, it's too late now for me, but these young kids out here, they need some help. And you know, another thing, First Amendment right means that I can talk. You know what? some people that I know on the street told me, why did I put them down? Well, bring your behind over here, and then you don't have to worry about me saying anything about you. If you out there now listening, I'm gonna turn my back again. It's not on them because you're not over here saying anything to them about nothing. So I'm turning my back on y'all, not the council, but y'all. Don't forget it.
Thank you for your comments, Mr. Brown.
Mr. Fane Lozman and Miss Margaret Shepherd.
Mr. Lozman?
Mr. Fane Lozman,
Yes,
and then Miss Margaret Shepherd afterwards.
yes. Welcome, Mr. Lozman.
Fane Lozman. I'm not sure where to start. Somebody made a good point, the 5 final policymakers. You set the policy for the city. You've never set a policy that it's okay for your staff to violate the American with Disabilities Act. So some of your individual employees under you have done that. It's despicable. And there's a federal remedy to see if they can have a finding of fact where it can come back to you and you can say, okay, you violated the ADA Act. We cannot have people working for the city that do that. And then you can take action, hopefully to terminate these employees. Earlier this year, I filed a lawsuit saying that the city manager did not have the authority to hire the police chief. If you look at the charter, that used to be the responsibility of the 5 elected officials, and then they changed that by ordinance, the charter, that the city manager could do that position, could do that hiring. I said, talked to a lot of people, did my research, that state law says that that change must have had to go to the voters. It never happened, so it's void ab initio. The city has come back and argued, their attorney, that, oh, well, the statute of limitations ran out. There is no statute of limitations when something was changed illegally that couldn't be changed that way. It's like it never happened. So the 5 of you, as far as I'm concerned, have the authority to hire or fire the police chief, and you actually do the selection process, which is what you would want to do. You don't want to have all this power stuck in one individual. Well, what's happened now is that I'm being retaliated against by the city manager through the police chief, that I'm not getting police services. Somebody came and ripped down my sign, on my property, threw it in the garbage. Dan Taylor called up police and they never came to take a report. Dan Taylor, he couldn't be here tonight. He has been threatened 24 times, 24 times by Summers, that Summers would arrest Taylor, take him to the county lockup on a weekend where he could catch COVID. Osgood said Summers has to leave the island. Botel fought for Summers, and ultimately Evans micromanaged Osgood and kept Summers on the island. Summers has threatened me repeatedly that he would take me and arrest me on a Friday to county jail so I would get COVID over the weekend. Okay, one day I may get my head blown off by Summers. Okay, I don't feel comfortable going to my property when Summers is still on the island, nor does Taylor. Okay, we filed internal affairs complaints. The police chief has done nothing about it. Police chief was supposed to meet with me months ago. He's not doing anything about it. I've had other incidents with police officers that they think they are emboldened just to ignore me and to ignore the complaints that Dan Taylor has done. There's a remedy for that type of behavior. We're going to pursue those remedies. Thank you.
Thank you for your comments, Mr. Lozman.
Miss Margaret Shepherd, and then Miss Evelyn Harris Clark.
Welcome, Ms. Shepherd.
Welcome, Mr. Chair. Margaret Shepherd, Riviera Beach. Before I start, happy anniversary, sir. Very proud of you, young man. I'm here today because I think the last time I was here, the subject came up about Mr. Elam. I don't know Mr. Elam. I don't know him, and I've been here a little over 45 years. I know I'm acquainted with his mother, but I do know Miss Olivia Franks Edwards. When I first come here, Summer was just 4 years old, little bitty thing. And I was terrified of letting Summer get on the bus and go down to Opelika, Liberty City, because I went down there and I was scared myself. But Mrs. Franks came to me and John Lee Williams, they reassured me that when my baby got on that bus, she would be protected. So I did go a couple times, and I did notice that they had a plan. John take the boys and Miss Franks takes the little girls. And they didn't have no handy wipes or gloves or anything. And Miss Franks had to go into the bathroom and sometimes help the little girls. So if she had a charge on her or whatever, and down through the years I found out this was going on, I would be flabbergasted. But Mr. Elam, I understand what happened at Notre Dame. I had people really explain it to me, so I understand. But we have to be careful. I think I heard somebody say that they'll go over to another program. And you got to be careful because the FBI said they were watching. I don't think the FBI go away. They allow you to go and do whatever you do, and then they come in and reel you back in. I just want you all to be very careful. 2 good families has been hurt. The Elam family, which I don't know him, but I know his mother, and to Miss Franks, I knew her mother and her father and all her sisters. And I was very hurt because I did not know all this was going on. Unfortunately, I don't get in this chitter chatter like some women do and try to make it their destiny to take you down. But if I could say one thing to those 2 families, I am so sorry this has happened to you. I apologize from the bottom of my heart because someone made the mistake that Mrs. Franks, this was her job to vet out people. I think, Mr. Chair, I'm not sure, who comes into the city. I'm very proud because my granddaughters, both of them, I put in the hands of Mrs. Franks and John Lee Williams. And John did not play, and neither did Miss Frank. They protected those children. When they got on, and Miss Gwen Oaks and KP, they protected those children going down the way. I thank you. And once again, I am so sorry to these 2 families. Thank you.
Thank you for your comments, Ms. Shepherd.
Ms. Evelyn Harris Clark, Ms. Delcia Hamilton.
Go, Ms. Clark.
Yes, 133 West 11th Street. Good evening, council. I would like to speak on behalf of JS12 Real Estate Holdings LLC. The applicant was here earlier. They have been at the CRA meeting, and the board has passed a lot of their requests. But let me go ahead and speak. This is in regards to that applicant requesting a 30,403 square foot 2-story boat rental or boat dealership with an outdoor boat storage area. And the subject property is located at the southwest corner of the intersection of West 12th Street and the Broadway corridor. I was here with another resident, Miss Phyllis Adderley, but she had to leave. So I'm speaking on behalf of her. On behalf of those concerned residents whose neighborhood is going to feel the impact of the new marina boat dealership, we extend our appreciation to the developer who heard us out. The only entity interested and kept their word to bring all parties together to listen, discuss, and figure out how commercial and residential can coexist under the downtown general zoning district. The applicant has agreed to incur and spend additional dollars to go beyond the basic security metal fencing and add an attractive 6 feet high stucco wall around its property perimeter facing our residential homes to complement the up and coming neighborhood. I say to the residents of Riviera Beach, don't become complacent, frustrated, or dismayed, depending on others to manage your concerns. Until you leverage smartly your energies towards a win-win solution for all parties involved, it will not happen. The few property owners, we approve their application with said promised considerations mentioned above. And just lastly, in regards to recovery homes, sober homes, we understand mental illness and we understand addiction. It is the property owners that are unregulated, mismanage these individuals. When they get kicked out of their sober home recovery program because of lack of insurance, it's not until one of those individuals end up in the front of your house in your flower bed unconscious and possibly dead that you have to deal with it. So I'm hoping that you really look at what you need to do to get this under control, because it is the residents who ultimately see these situations of the people left behind, living behind your house, falling unconscious in your flower bed, or breaking into your property. Thank you.
Thank you for your comments, Ms. Clark.
Ms. Delcia Brooks and Ms. Cindy March.
Good evening, Council, Mr. Chair, City Manager. My name is Delcia Brooks Hamilton, and I am the owner and CEO of Pangea Grill. The reason I am here is because I started this process, and I know a lot of people know me. The community know me as well. I've been coming to these meetings and events since 2015, and I know you guys always hear me say my persistence and determination, pays off. Well, it has paid off because now I have the opportunity as a minority Black woman, business owner, to put a 4-star, 2-story waterfront restaurant on the marina. And I know that the community is also very excited to see me participate in this process because I think it's long overdue and I deserve it. My consistency has now paid off. And I remember back in, I think it was August 28, when Tony Brown said, Miss Brooks should have pad site number 2, which was back then it was pad site B. And I always questioned him, why pad site B? He said, don't worry about it. You'll find out why. So I just want to thank him today for selecting me back then. And now he has the opportunity to finish the job that he started. And I also have the opportunity to finish the job that I started back then with Tony Brown. So I want to commend him for his consistency, persistence, and determination to get the job finished. That was not completed, but now he has an opportunity to do so. I also have the opportunity alongside with that team to get the job done as well. So I want to commend council for moving forward with Marina Phase 2 project because it's long overdue. The city needs to be on the map. We need to produce new entrepreneurs. We need to be selected as Black owners in this city. And I am here to say that I appreciate you guys for moving the project forward. And I am so happy. I'm so ecstatic. It's been a long haul. It's been very stressful. I go to sleep thinking about it. I wake up thinking about it. So I just want everybody to know that it's been a long haul and I haven't taken it lightly. I'm ready to go. And the time is now, and I need to be recognized. So thank you very much.
Thank you for your comments, Ms. Brooks.
Ms. Cindy March and then Ms. Williams.
Good evening again, Council. I want to first say congratulations to you. I see you coming up here fighting all the time. Won't he do it? I'm glad for you. Number 2, I don't really want to elaborate so much on Elam, but the only reason why I'm saying what I'm saying, I'm like Ms. Shepherd, I don't know the story. Both families hurt. The only reason why I spoke out the week that I spoke out, because Randy called my phone. I guess he's married to the young lady that worked over here or whatever. My fight ain't everybody's fight. I'm not fighting for nobody. I'm a leader. I'm not a follower. But when Randy called me and tried to give me the spiel about it, and trust and understand where I'm coming from. Elam is some kin to Lady's son. Have nothing to do with it. When you're right, you're right. When you're wrong, you're wrong. I can't determine whether that man was wrong or right. But what I can determine is a phone call that I received about Alston Evans. And you all know I don't, and Evans, you know for yourself, I have came to this podium plenty times and spoke against Evans. But what I'm not going to do is trying to bring somebody down that have done nothing to me. That's called personal vendettas, and you going against a grain of salt that you don't know nothing about. That's not who I am. Yes, I have said some things about several of you alls up there because I call it the way I see it. But when I got to call it the right way, I have to call it the right way. So I just straight up told Randy, when you cross all your T's and dot all your I's, then you can come to me. But to tell me, get on board to help get rid of Evans for this kind of foolishness I don't know nothing about, I'm not on board with that. It's just not me. And another thing about these sober homes, my story is somebody else's glory. I'm not ashamed because the personal relationship I have with my God. Yes, we need a mental illness place. Yes, we need a domestic violence place, shelter. Yes, we need a sober home place. We can be up to date and down to date. But what I'm saying, stop letting these few people come up here and dictate to us when we don't know the terminology of what's going on. And Traja don't need no cheerleader, but Traja McCoy, I just want to say, if don't nobody else appreciate you, I appreciate, because I'm the one go and knock on these people's doors, and I've been doing it for over 30 years. I don't tell people who to vote for. I tell them to learn your candidates for yourself. You understand me? Whether you looking at TV or you in here, watch how crowded this place get when it's time to vote. That don't mean a hill of being good. If the city of Revere Beach not in your heart, and you're not coming real with it, if you're coming for a show, you don't need to be in this building. Because the city of Revere Beach is a place where we would love to live, work, and play.
Thank you for your comments, Ms. March.
Ms. Williams and Ms. Doretta Park. Ms. Williams.
Ms. Williams, go ahead.
All right. To the mayor in his absence, to my chairman and the council, I would like to give honor to the police department. I guess we all heard the shooting in Riviera Beach today, right? It was terrible. And do you know it was right on my street? Right on my street. With that, what they call it, AK-15 or whatever. Jesus Christ Almighty. And to the members of the city. Well, I can thank the police department coming from there, but I'm going to tell you how good God is. I heard all the shooting. I just came back from a pantry. I pick up stuff to get to different people. And I was going to turn and back in my driveway. But God say, drive straight in. When it's straight in, I heard all the shooting. The car was speeding. I mean, that car got shot up and it was speeding till they shot the bump off, everything off, and the tires and holes all in it, just drug up from the top of the hill all the way down to the end. But I just thank God for God being God. And Mr. McCoy, I want to give it to you too. I don't care what come up on this board here, and they be saying things. What they say, you ain't no chicken picker out. You pick the truth out. And I thank God for you too. And y'all, I didn't hear, maybe I got here late by Amazon. Remember that's right down the street from me on 13th Street. That was supposed to have been done 3 years ago. This is not being done because of voting time coming up again, 3 years to get it. But thank God it's here. I would like to comment if they're going to do a sober house. Is that going to be built over on St. Island? Okay, but you said we got such a bad area over here with drugs and stuff. You put one over there too, and you put one over on the west side. Build it the same. It's a lot of sober people need that. I work with them out down the street. I feed them. I could tell you how bad those people, not bad to hurt nobody, but they are desperate and need help. So we just want to do a double. Build one on our side and build one over there too. Make it be. I don't want it to be like you did the school they fixed up Kennedy, and then they built one further down, and it made it better. but we want them both to be the same, and the people do need help. Whatever the rules and regulation is, I've been out to the county jail 40 years, and I see those people coming in incarcerated, going out and coming back. Help them all you can, but don't be trying to disciple them or put them down, because they do need help, and some of them have fallen from grace, like many of you with profession, and given up, and they terrible out there, and they need our help.
Thank you for your comments, Ms. Williams.
Ms. Doretta Park, and then Ms. Mary Brown.
Welcome, Ms. Polk.
Good evening, Board. My name is Doretta Park, and I'm a citizen of Riviera Beach. And my deepest condolence goes out to Mrs. Flora Gorbert. She was a retired educator in the Palm Beach County School System. She also was a member of our Park Manor Association. She also strived diligently for the Lindsay Davis STARS program. And STARS stands for striving, stimulating activities for remarkable seniors, stimulating activities for remarkable seniors. She did many things over there at Lindsay Davis before her passing, and all she ever wanted was for the betterment of Lindsay Davis for all the seniors that come into the center. And may she rest in peace. And I went to an amazing ribbon cutting at Long Pine last weekend. It was very lovely, sponsored by our pro tem, Ms. Lanier. And it was really wonderful to see Miss Lydia there. It was really wonderful. It was a very nice. And then Miss Botel, Councilwoman Botel, she brought in some spinach and a tomato plant, which they were supposed to hopefully plant out there in the park, which is a very lovely gesture. Now, I just want to talk about the last meeting. It was stated that possible a raise for all you council people. And I'm not saying that you're not deserving, but how could you consciously even think about giving yourself a raise when our water bill is increasing, especially for the seniors, as myself and the other seniors in the city of Riviera Beach, and every senior in the city of Riviera Beach. So what is it? You get it? What about all the, I wouldn't say it with perks, but what about all the allowance that you all get? Car allowance and other things? Mr. Evans, if you can look into what other cities council people get for when they get raises, are all of those things included? I just don't think this is the time to even venture to approach a raise, because a lot of seniors are having a lot of hardship. And I thank you very much.
Thank you for your comments, Ms. Polk.
Ms. Mary Brown.
Welcome, Ms. Brown.
Ms. Mary Brown, good evening, Board Chair and Board members. October is Breast Cancer Month, and not only for the women's as well as the men's as well. I was engaged today with various management and leadership up in North Palm Beach. I sat at the table today. And first of all, I'm going to tell you something here. sometimes people in organizations, because see, I've been there. The city of Riviera Beach got the best of my employees that stayed here for numerous of years and they retired. They was under Miss Bram Ospic. I believe in putting people in the right places because sometimes they are not destined in the places that we put them in because they cannot literally rise to their full potential because we put them places where they shouldn't be. And it's okay to move you out so that you can grow where you need to grow. That's one thing. Miss Elizabeth McBride, the Deputy City Manager, I do, as well as wish her a speedy recovery, as well as Miss Ernestine Gordon, that has been a true servant of this city for 50 plus years. And I want you all to know she will be fine, just fine. You can bank on that. That's who she is, and that's where she will remain. 26 pages here in this 8-mile stretch of city territory here. What asinine minds of leadership would you do this? 6 months ago, a sober home came into my neighborhood. Nobody is on guard. Where are the officers? 10th Street over there have been busted numerous of times for drugs. She was right. Publix over there 4 months. The guy laid there 4 months. The customers complaining about the smell. The undertakers kept coming into the Publix, letting them know that a dead body was there. A police went over there. He didn't see anything. But guess what? The dead body was there. And we talk about regulating these things here. What leadership does this when we're trying to move our city in a positive direction? I got them down the street from me. I got them in the back of me. She talk about all this shooting here. Where are you all minds at as leadership? We are 8-mile stretch of territory here. Do not do that. We're watching you. Do not do this asinine craziness for this city here. Do not do that. Thank you.
Thank you for your comments, ma'am.
Mr. Chair, that concludes public comments.
Congratulations on your engagement.
Thank you. Thank you, Madam Clerk. Mr. Evans, you want to comment on the comments from the public?
Mr. Chair, very briefly, with regards to the drainage, obviously, I think we've seen all throughout the county and throughout the region, based on the volume of rain and the saturation levels in the ground and the groundwater table. That's where we had localized flooding throughout the city, and I think every city dealt with that because of the issues that we did have. In some cases, the water is still receding and making its way. And so we understand that it was an inconvenience for a lot of persons, but the drainage infrastructure, just the amount of volume, couldn't handle it at that particular time. And, it's no different than the incident that they had in Fort Lauderdale that was basically a 1,000-year flood that they had that actually flooded out the airport. And so obviously staff was responsive to the complaints that we have. Even law enforcement or public safety, the fire department did respond to Lone Pine based on some of the calls for services, but it was definitely a drainage issue and not necessarily an infrastructure issue. It was just the amount of rain that we did receive at that particular time. It also was referenced earlier about the Amazon facility. They have had their first employment workshop here in the city, and I think they're going to do another one, but they are set to open right before the holidays. And so one of the things that they did want to invite the board for an opening ceremony, and so information will be coming out with regards to that. And so that concludes my comments, Mr. Chair.
Thank you, Mr. Evans. Board. All right, ordinance 4236, Madam Clerk.
Ordinance number 4236, an ordinance of the City Council of the City of Riviera Beach, Palm Beach County, Florida, amending Chapter 28 signs to update the definitions and regulations pertaining to temporary signs, and for other purposes, providing for severability, providing for the repeal of laws in conflict, providing for codifications, and providing for an effective date. Mr. Chair, we do have public comment cards on this item. The acceptance of public comment cards for item 9E are now closed.
Motion to approve ordinance number 4236.
Second. Madam Clerk, I'm sorry, Mr. Evans.
Mr. Chair and members of the board, if I can have the Director of Development Services, Mr. Clarence Sermons, to make this presentation.
Thank you, Mr. Manager. Good evening again, Mr. Chair, members of council. The ordinance before you looks to make some amendments to the city's sign code. These amendments were deemed necessary because of changes in law, particularly case laws related to signage and freedom of speech. Staff has worked closely with outside legal from Torsivia Donlin Gatto on crafting this ordinance, and to provide you with more details on what's contained in it, I would like to reintroduce Attorney Tanya Early. Ms. Early.
Thank you, sir. Good evening again. So in 2015, the United States Supreme Court decided Reed versus Town of Gilbert. In that case, the court held that regulation of signage based on content is subject to strict scrutiny in determining whether or not such regulation is constitutional. Strict scrutiny is a very high burden and a difficult one to meet under the law. And it was determined that at least one area of the existing code should be updated to ensure compliance with Reed. And that was specifically with regard to the definition of election
Chair.
signs.
Councilman McCoy, go ahead.
Ms. Early, can you speak a little bit closer to the mic, because the audio doesn't work very well up here.
Yes, sir. So can you hear me better now?
Yes, ma'am.
Okay, wonderful. So with regard to section 28-1, which is your definition section, the prior definition of political sign, which might potentially be construed as referring to the content of the sign, has been deleted, and it's been replaced with something that is purported to be content neutral. So now an election sign is defined as a temporary sign other than a real estate or construction sign that is displayed during the 45-day period immediately preceding a local, state, or federal election. A temporary sign is further defined as one that is not permanently affixed or installed, or one that is displayed for a limited period of time. There were additional amendments to Chapter 28. They are as follows. The title to Section 28-109 has been amended from real estate signs to temporary signs. There's been a preamble added as indicated on the screen, and that they are indicating that temporary signs are allowed only as delineated in that section. And it creates new subsections C, D, and E regarding election signs. Subsection C applies to residential properties, D applies to non-residential properties, and E applies to all. Subsection F was added with regard to enforcement. Subsection D, as I said, deals with residential properties. And for residential properties, you may have freestanding signs, or you may have signs that are attached to a window. They cannot be not attached, but showing through a window. They can't be affixed to building walls, fences, utility poles, or equipment, etc. They cannot be placed in the public right-of-way or on utility easements. They can't interfere with street sidewalks, medians, drainage, ditches, swales, or utilities. And no more than 3 election yard signs may be displayed per residential parcel. There is a limitation as far as the square footage of the sign, that they should not exceed 2 square feet, nor 4 feet in height. With regard to the next subsection D, non-residential property, many of the conditions are similar. However, Notably, the signs must be freestanding. They cannot be displayed in a window as with residential property. Furthermore, there are limitations as far as one election sign per street frontage may be displayed per parcel. And finally, there are different standards when it comes to the dimensions of such signs. They can be much larger, up to 16 square feet for parcels less than 1 acre and up to 32 square feet for parcels greater than 1 acre. The height limitation is going to be 8 feet on those. Subsection E, this is the language of that entire subsection. It just says, it reiterates what's in the previous subsections, that they can't, election signs cannot be placed in a median or public right-of-way or on public property. As far as enforcement is concerned, the new subsection, it deals with violations. It says the city shall have the right to remove any temporary signage in violation of this section, and any failures to comply with these regulations may result in enforcement proceedings through Chapter 162 Florida statutes. That's basically saying that any violator of this new code could be sent through the code enforcement process and have to see a special magistrate. And that's basically it. The goal of the ordinance was just to do some cleanup and to ensure that the city's code of ordinances is in compliance with the case law that's come down from the U.S. Supreme Court.
Board members? Do we have any public comments, Madam Clerk?
Yes, sir, you do.
I'll take public comments first and then questions from the board.
Ms. Paige Parker and Mr. Fane Lozman.
Good evening again. I was hoping we were going to talk more about not only election signs, but all signs in general that are non-compliant, where people are just tacking up signs on street signs, light posts, wherever they can find a spot. I'm sure we all now know where we can buy a French dog, bull, puppy. We can get a DJ. These type of signs not only are eyesores to our beautiful city, they're also dangerous, and they promote dangerous business practices. People that are advertising for labor, construction help, we don't know if they're licensed. If you are a licensed professional in those trades, you have to display your license number. One of my favorite ones came up this weekend. I don't know if y'all saw it, but we rent 3-bedroom pool homes. So I called the sign as a realtor. I was very curious how much they were going to rent their house for. And this homemade handwritten sign with little pinwheels on the side with duct tape in the middle of the median was definitely not code compliant with the city regulations for signs or as a realtor for the state, for the county. So I called. They weren't offering a house to rent. They wanted to rent your house. They wanted to sublease your house. You sign a lease as the homeowner, and they're going to go rent your house nightly, weekly, monthly, whatever they want. Very, very dangerous and legal in the state of Florida, but on a very fine line. So they can sublet your house to whoever they want. You sign a year lease with them. They can get as much money as they want. They don't have to pay short-term taxes. The owner does. Does the owner know that? Probably not. And also, these people can do improvements to your home. A contractor can come put a lien on your home, even though this sublet person did this. It is a big, scary scam, and just one example of how illegal signs promote illegal and dangerous business practices. So I hope we're really putting our eyes on this. Thank you.
Thank you for coming, Mrs. Page.
Mr. Fane Lozman.
Welcome, Mr. Lozman.
Fane Lozman, at the 2021 election, signs were placed, Botel's campaign signs were placed on my property at 5101 North Ocean Drive, and they were placed on the property on the north side of Pine Point Road. Dan Taylor, who's the principal for Taylor Realty Group, he has the Adopt a Highway program on North Ocean Drive. And one of his responsibilities is to pick up litter. In exchange for picking up litter, he can post that he adopted that highway. So Botel had put her campaign signs in the median, in the right of way, and on private property. She and her assistant there, Sammy Brown. So we went and we removed those signs. And then Summers, that's when he started. Well, he had started it earlier, but he started coming and threatening us that he was going to arrest us for removing the signs. First of all, the signs were on property that I owned, property that Taylor owned, and they were also in that state road where you're not allowed to have campaign signs, that we were tasked with responsibility of removing them. Ultimately, it morphed into a lawsuit where Taylor was the lead plaintiff and I was the follow-up plaintiff. And we had the then city clerk, and she confirmed that campaign signs are not allowed on public property or in public right-of-ways or on state streets. Now, one of the confusing things that I saw in the presentation here, it says cannot interfere with streets. What does that mean, cannot interfere with streets? That was up on the PowerPoint. That makes no sense to me. You either can have a sign. Can you have a sign on a street that's not a state street, like alternate A1A? You know what I'm saying? That's a city street. Where exactly going to put these signs? During the election, you go over to Wells Park there, you see signs, 1,000 signs all wrapped around that street there. Are those all illegal now because that's technically public property where Wells Park is? Or if you go along this old City Hall street, there's a ton of signs. So it's not clear to me what they mean for streets. We knew under state law, you can't put any signs on alternate A1A North Ocean Drive. We clarified that right off the bat. But what about all these other signs that are being put about? And I guess the other question is, what about enforcement? Like Dan Taylor put up a couple big real estate signs on our property on North Pine Point Road. Matt Lynch went and cut them down. And he said, yeah, I cut them down because you're not allowed to have a real estate sign over on that piece of property because he said it was zoned special preservation or something. First of all, that's not his decision to make, but when somebody admits to cutting down a sign and the police take no action, what remedy should a property owner have when somebody cuts down a real estate sign? Okay, so there's a few questions as far as enforcement, signs that are on city streets, signs that are on private property. What remedy do people do on those topics that I addressed there?
Thank you for your comments, Mr. Lozman. Board members? Discussion?
Yes.
Councilman McCoy, go ahead.
I don't know where to start, but let's go with the most obvious. And this is one I've already addressed with seemingly nobody has responded. And Ms. Early, thank you for your efforts. But I got to say, Coach, we got us one. Because clearly, I don't know who puts this stuff together, but there is too much staff time wasted on stuff that's fundamentally and factually illegal. And I won't be supporting this item for several reasons, but the most glaring one is the one that this says violations. The city shall have the right to remove any temporary signage in violation of this section. Well, let me tell you what I experienced from a constituent call. A few months back, well, about a year and a half ago, a gentleman reached out to me because he had burglaries on his properties, trespassings on his properties, and he made a police report, and the police informed him that he needs to post no trespassing signs on his property. He did so, and let's guess what happened. Code enforcement came by and seen a vehicle, his work truck, parked on his commercial property. Contained in his property were also no trespassing signs, which were conspicuously displayed on all sides of the building and had been for at least the last year and a half. So they decided to go onto his property despite the no trespassing signs, tag his vehicle. Well, that's not the worst. About 60 days later, because he was traveling back and forth to New York, Code decided to go back onto his property with the police and to illegally tow his vehicle off of his own private property despite the no trespassing signs. I don't know where we live at, but there is clearly constitutional protections against unlawful search and seizure. So there's no way that I can support an ordinance that the very first violation is that we can embolden citizens to embolden employees to walk onto someone's private property to remove a sign. That's not right. The police can't can't go into someone's vehicle. They can't go into someone's house. How are we going to allow code to sit here and go onto someone's property? And this is the kind of stuff that you don't like what I say, but you got to appreciate it because it's science today. What about it's your personal property tomorrow that government is coming onto your property to take it? All because somebody didn't make sure that they checked the box when reading and approving these ordinances. That sounds like the most bizarre thing I've ever heard in my life. And clearly, you spoke about this constitutional case with Reed going up to the Supreme Court. I don't even know how that have possibly come up, Ms. Early, that staff can be permitted to go onto private property and remove a sign. Under what way, without any kind of search warrant, can you do that, Ms. Reed? I'm sorry, Ms. Early.
So, Mr. Chair,
Ms.
council
Early, go ahead.
member, can I make a suggestion based on what I heard? Might you
No,
consider?
I want you to answer the question because I don't know how we can even arrive at this. And there's so many checks. I'm still dealing with a gentleman that calls me weekly about him paying a tow bill because the city can break the law. But had it been him going onto the city's private property, he would be certainly reprimanded. So how is this even in the ordinance? And that's my question.
So generally speaking, code enforcement can enter private property to abate a nuisance. There's a procedure for that. I think that you make a good point, and perhaps it might make sense to amend the language such that the city can remove signage that is placed in city right-of-way on city property or something of that nature, or blocking an easement, or for public safety. Maybe you want to include qualifying language that would make it more defensible.
Okay, so you would agree that that's not reasonable to go onto someone's property despite there being no trespassing signs? Because truly, I mean, no trespassing should apply to government or to the state.
I'm not sure how to answer that question. All I can say is, if you would like the ordinance to be rephrased, we would be happy to assist with that.
The next item is, I don't like it in there, period. Let me say that. But the next item that just jumped out at me was particularly, we referred to election signs. I don't like that we're targeting election signs, and more or less because you don't refer to it as political does not eliminate or remove, Ms. Wynn and Ms. Early, the protected free speech. Because I see more code enforcement signs when there's violations on property. So you're telling me that a code enforcement sign can exist, but the person that's what's the saying? You should know what it is. Make America great again, or whatever the sign is. So I mean, a person can literally have a code enforcement sign placed on a piece of property that is legal, but you can't have a Make America Great Again sign. That seems to me that you're completely eliminating one form of speech in exchange for another, even if it's a notice. So how do you reconcile that, Ms. Early?
So the proposed section 28109 relates to temporary signs, and it lists the types of temporary signs that are available and that are permitted, within the city. And they are listed in there as real estate signs, construction signs, and election signs. The election signs are not, the goal is not to have content-based restrictions. The goal is to restrict based on other factors, including visual clutter, etc. And so the reason why the language as amended as it applies to election signs, I believe would be legal, is because there's no reference to the content of what is on the sign. I don't believe this particular ordinance contemplates signage that might be utilized by city staff, for example, posting a property that's coming up for a change, that's coming up for a zoning change or something like that, or a code enforcement sign saying your property is being cited, et cetera. I think that's outside the scope of this ordinance. And to the extent it needs that language qualifying it, that could also be added.
I mean, it's a semantics. You say potato, I say potato. So you call it election speech, nonetheless, it's still election signs, nonetheless, it's still political free speech. Would you agree, Ms. Early?
Mr. McCoy?
Ms.
Mr.
Nguyen,
Chair, if I
Attorney
can.
Nguyen, go ahead.
Right, and I'm sure you heard her, and I don't mean to continue to repeat, but it's not about the content. So when you say election signs, we know what they are, and you can say whatever you want on election signs, but this regulates, for instance.
We don't know what they are,
The
Ms. Nguyen.
size of the sign, those types of things.
Right, but
And just to address another point that you made earlier, we've added the section on election signs and then signs on residential and non-residential property. However, we've always had the ordinance dealing with all these other signs, snipe signs, directional signs. These are just amendments to those three those three areas. But we've always had this sign code.
okay, so if I can finish, Ms. Nguyen.
Councilman McCoy, go ahead.
So what I'm saying to you is you've added it, but there's no definition of what an election sign is. The only thing it says is during the 45-day period immediately preceding a local, state, or national election, temporary signs may be placed on the residential property subject to the following limitations and requirements set below. But what is an election sign? This ordinance does not even define what an election sign is.
The definition is on page 5. Election sign means a temporary sign other than a real estate sign or a construction sign that is displayed during the 45-day period immediately preceding, as you stated, any state, local, or national election.
And that's my point. So if you're outside of the 45 days, then technically it's not even an election sign under the code. Under what you're proposing here, if I place an election sign to my good friend over here, re-elect Kashamba Miller Anderson for District 2, and I post it up in December. So by that very definition of the code, then technically it's not an election sign. And that's the point that I'm getting at. You're defining an election sign by the number of days that it is before the election and not what its main characteristic is to encourage a person to vote for a candidate. Or
I think the reason that it was written that way was to ensure compliance with the Supreme Court case law, because the Supreme Court has said you almost can never regulate signs based on content only. It will be subject to strict scrutiny. So in order to avoid any reference to the content of the sign, this just says all temporary signs other than a construction sign and other than a real estate sign displayed within 45 days of an election. It is an attempt at content neutral regulation.
sure, I got it. But my question is, 120 days out, a re-elect John Smith or elect John Smith sign, is that considered an election sign under this code definition?
It is not, and it would not be permitted unless it fell under some other category that was allowed. So the answer is no. The short answer is no. It's not an election sign.
Okay, so see, because I guess I don't understand. It's not an election sign, so there's no other definition for a sign outside of 45 days that encourages someone to vote for a candidate.
That's the way that the ordinance is drafted. Yes, sir.
All right, I got it. And this is what the clerk has been working on with you guys?
I'm not going to bring I don't know
Well,
that the clerk has
well-
worked on this at all,
Well,
sir.
she specifically had it a part of her goals for the new fiscal year. So certainly I just want to make sure I know who all is involved in this, because clearly this is another piece of half-baked ordinance. I mean, I guess.
Go ahead. I'm sorry, Councilman.
I would assume that there's going to be an action to modify it based on the violations.
Mr. Chair,
Ms. go ahead.
Mr. Board Member, or Mr. Council Member, excuse me. If it is the direction of the council to do so, then absolutely we can modify the language.
Right,
Yes,
but
sir.
it shouldn't be a direction of the council. Fundamentally, it's illegal what you're you're suggesting to go onto someone's property to take something, why should it be the direction of the board and not the attorneys that drafted it?
Sir,
Thank you, Mr. Chair.
Thank you for comments, Councilman. Oh, Pro Tem Lanier, did you have?
Yeah, I just wanted to say that I do have a little issue with this in regards to enforcement. I think that it's going to take a lot of resources to enforce this. That's number one, because I think that, you know, during previous election cycles, you have public works that are going out every day, picking up signs from different places, which is fine. But I think it's going to deplete a lot of the resources that we have. But that's not the main one for me. The main one for me is possible legal challenges to it. I think that a lot of municipalities have tried to enact sign legislation, especially as it relates to election and politics. And I want to say somewhere like in Juneau or Jupiter, there were signs that had like just red MAGA hat signs that kind of went to court, and people said that no, they can put what they want to in their yard, and if they want to, in an appropriate place in the city. So there may be some legal challenges to that as well. And then also too, when you talk about election signs, you have to remember that there are a lot of grassroots non-incumbent election political candidates who may want to jump into the race but do not have the money as an incumbent or the funding as an incumbent to be able to keep up with that in a sense. So that really is going to put a hinder on just getting people who want to be involved in their political government, who want to say, I want to get in this race but don't have a whole lot of money. I think that signs go a long way. So there are some issues that I kind of have with this. And then two, just the fact that just the temporary nature of political signs is something that we need to look at. So I have a little heartburn with it. I think that we can tweak it some, and no slight to all of your work that you have done. But, you know, in City of Riviera Beach, the election cycle is brutal. Oh. That was right on cue.
Like you can stand an ovation.
That was right on cue.
Tawana said, "You right." Go
So,
ahead, Pro Tem.
yeah, that was brutal. So yeah, it's very brutal. So I think that we have to be very careful in how we word this and how we look at this. And I think that we need a little bit more input, not just from this board and staff, but the community as well.
Thank you, Pro Tem Lanier. Board members? Thank you. Ms. Miller Anderson, go ahead.
I would just like to go on record that this seems to come about every 3 years during this time. I just want to make sure that we realize that this comes at a certain time every time. And I just don't have anything to say about that. I really don't, because it's exactly the same timing, literally every 3 years. And I've said before, we need to do this when we do not have any elections coming up so that nobody feels that this is being done for a purpose. I mean, we have a year every 3 years where no one has an election. That would be the perfect time to do this so that no one feels slighted. But this, yeah. Thank you.
So I did have a question in reference to election signs, and we outlined size, dimensions, location, but content is based upon what's actually constitutes an election sign. How do we determine if it's an election sign or not, and how do we preface it? Because I have a sign that's been on my building for 5 years that can be considered an election sign, which technically it is. It was one of my original election signs, but it's also been a staple of my business. So how do we determine and constitute, and for personal edification, is that going to be something that I have to take down based upon this, with it being outside of the 45 days?
Mr. Chair, it's going to be, election sign is not defined by its content. And that's on purpose, as I stated before. So it is a temporary sign that is displayed during the 45 days immediately preceding an election. So its content could be anything, essentially. It's any temporary sign displayed during that time period that is not a real estate sign and not a construction sign. and so whether or not the sign that you're speaking of is going to violate the code is going to be determined by whether or not it's temporary in nature. A temporary sign, as defined by the code, is one that is not permanently affixed or installed, or one that is displayed only for a limited period of time. So I think the goal of the ordinance was to address, the signs that are stuck in the ground that are really and truly temporary in nature, not something that's been affixed to a building for an extended period of time.
Mr. Chair, if I
So
may.
then, I guess just a follow-up, hold on, Mr. Evans, and then I guess just a follow-up in regards to that signage. So it doesn't have to do with content, but if I just put in my front yard, or if I put in an easement or an access area that actually I have personal ownership to, that I want to say Kashamba Miller Anderson's the best outside of these 45 days, that is a legal sign that I could put out then?
It would not be under the code. It would be a temporary sign that falls outside of the 3 criteria that the code section allows. So if it's not an election sign, if it's not a construction sign, if it's not a real estate sign, then it doesn't fall under the criteria.
And I guess we're basing the election signs upon what state requires for signs to have on them as election information. Because I just want to be clear with what signage what it has to have content wise, because I could create or reference or preface something to determine it being outside of real estate election, just so that I can still get my message across, and it's still going to be counterproductive to what ordinance we're trying to implement. So I just want to make sure that we're clear with what we're moving forward with.
It's the temporary nature of the sign plus the timing of when it is displayed. And that is what the ordinance seeks to regulate. Because what we were trying to do is get away from targeting specifically political signs in any way, shape, or form.
Understood. Mr. Evans, and then go ahead.
Yes, Mr. Chair. One of the things that I want to make sure is clear as a result of this discussion is that I can tell you during the time in which the election process occurs, there is a lot of calls that are provided to staff about the placement of signs on city property in medians. They stay up for months. The candidates don't pick them up. They get into the roadway. They get into the drainage canals. They become a issue that staff has to deal with for a prolonged process. And so the intent behind the item that you're here is to try to get some type of control and compliance of the process, similar to that of 39 other municipalities that have something on the books that provide for a better management of the process. And so if it is a situation where the board doesn't feel comfortable in its current iteration, staff would certainly recommend that we pull the item for the purposes of more substantive discussions with the board. But it is definitely something that we want to put something in place, because and you all know that it gets to a situation where staff is on their phones at the property appraiser's website looking at a swale, and is it private property, is it public property, is it FDOT, is it ours, is it the county, is it the state, or what have you. And so it becomes very concerning for staff, and then staff persons don't want to end up touching the signs or removing the signs because of the issues that are associated with that. And so we're trying to get clarity with respect to this particular process and try to have something that provides for more understanding of what the expectation is. So if it is something that the board wants to table or have a more robust conversation about it, but I can tell you that we get the residents call us all the time and say, if it's on city property, if a sign's on city property, are you endorsing this candidate or that candidate? And then the other side of it is, if it is in fact open season, when the tattoo parlor or the CBD company wants to put a sign and there's no regulations in place, it provides for that much more challenging for us to manage. So, the board can handle it as they deem fit, but certainly some clarity and some direction would be appreciated. If you want to have this as one of your topics for discussion, we can set it for a more robust conversation and clean it up at a later date.
Councilwoman I'm sorry, Pro Temp Lanier, then Councilman McCoy.
I think that, yeah, this needs to have some more conversation about it. It's like you're regulating political content, but not really saying you're regulating political content, but then also you are using it as a temporary, saying it's a temporary sign. So it's kind of confusing. And I think that really the biggest issue here is just enforcement. One of the main reasons in terms of after the election is those signs that are left over, and also during the election of people putting signs where they want to. So I think it's just more of an enforcement issue, but we also just need to come back and look at this again, because really it's just too vague in a sense. And then two, it's not really regulating political content, but really it is. So I think we kind of need to go back to the drawing board and look at this a little further. And also as our councilwoman said, just do it in an off year, because it does look as if it's being forced because there's an election coming up.
Ms. Miller Anderson.
I just had a question about it says a total of no more than 3 election yard signs in the yards. I mean, I know when you all have an election, that's 4 people that run. So technically somebody wouldn't be able to put somebody's sign out, just saying, because they're typically, right? I mean, typically you would have that. So I'm just thinking if we were going to talk about something, that would be one of the things to try to address, because somebody will get left out, right?
Thank you, ma'am.
Yeah, I can't comment on this because this is, yeah.
Councilman McCoy. You said what you said.
Yes, I would agree. It is an enforcement issue, but fundamentally, right, it goes beyond that, Miss Early and Miss Wynn. This is a private property rights issue. I mean, how do you go onto someone's property and be able to tell them that their speech is now considered an election sign and therefore you're going to regulate it? But you can treat real estate signs and construction signs differently. You can call it what you want, but I'm in the same position. Well, I'm not in the same position, but I share the same thoughts as Pro Tem. But, in terms of enforcement, I can tell you there's a guy around town who is really good with that enforcement piece. His name is Winston Russell. He stole my campaign signs and he was caught on camera. He's the husband of Shirley Lanier. And that's your enforcement arm right there.
Mr. Chair.
Chair, let me just respond that
Go ahead.
actually,
Councilwoman.
I'm not married, so that kills that. But, Mr. McCoy, if he does not agree with someone or something, he denigrates into personal attacks, which is not constructive for trying to do business for the city. That's just how it's supposed to go. It is something that we were supposed to do as a board. And also it is something that cannot be personal, which Mr. McCoy all the time makes it that way. But that being said, I think that it only should apply to public property, not someone's home. Because if you look at the 4 individuals who are coming up, you also have about 2 bond issues that are going to be on the ballot. So you certainly, but that'll be 6 signs if you voted yes or no for those candidates or for those bond issues. So I really think that it has to come back to us in some form where we can look at it where there's not an election coming up, and also too, when it talks about private property, how you regulate that, because I think it's very difficult to regulate what someone puts on their private property.
Ms. Miller Anderson.
Aside from just the comments that I made previously, I do think we need something. And, I agree with you. The signs get out of control. They really do. But I just think we need to really take a look at what we're saying in here and then the timing of it. And I guess it really is an issue for me because this has literally happened. I've been here almost 9 years. This literally happens every 3 years. This cycle comes up. So yeah, I do feel that this is being done during those times. And I've said this probably 3 other times, but I do agree we need to have something, but we do need to have a discussion as to how this rolls out. And I would like to know did we look at other municipalities in terms of like because I think one part of it talked about the signs could be no higher than 4 feet or no taller than 4 feet, and most places are like 6 feet or 8 feet. So I would like to see how this ties in or how this compares to other municipalities. But I agree, we do need something because I think sometimes not just our local elections, some of the like congressman elections, I mean, they will put their things here and you never see them anymore. Their signs will stay forever. And it's like they forgot they put them up here. And so they don't typically pick their things up and then they put them any and everywhere because we technically don't have something to regulate as well as other municipalities. Some places I know like Wellington, you can only put it in certain little spots and everybody has to put all their signs on top of each other basically because they only give them like a 5x5 area to put all their signs. So I don't know that we need to want to be that strict, but we do need something. But like I said, it's just for me right now, it's just the timing of when this ordinance always comes around because it comes around at the same time, almost every 3 years. Thank you.
Thank you. Madam Clerk, do we have any public comments?
I believe you already
Did we
had your
have those?
public
those?
comment.
We had them
It's been a
already.
while. Okay. Any additional comment? Councilwoman Botel, go ahead.
I'm happy to withdraw my motion if it helps us move toward a place where we can have further discussion and a workshop or something.
I would agree that we just need to have some further discussion.
I mean, I agree that I'm with Kashamba. It does seem to come around just before every election, but we do need to do something about it. I mean, the way the signage litters the city, everybody complains about it. So we've got to have some regulation, but it seems to me by hearing the conversations, we need a little more dialogue about it. So I'm happy to withdraw the motion and we can maybe decide to put this on at a later date.
Okay, Board, Councilwoman Botel has withdrawn her motion. I withdraw my second. Mr. Evans, do we want to just go ahead and bring this back at a later date? You want to
Mr.
have some
Chair.
discussions one-on-one with the board? How do you want to proceed?
Yeah, we can set this item for 3 years from today.
It'll come around.
We can have it as a workshop
Yeah.
item, and it can be something that's actually considered for adoption, in the off year or what have you.
Yeah.
But yeah, we can.
Thank you, Mr. Evans.
Okay.
Madam Clerk?
You go into item 11A.
Yes, ma'am.
Resolution number 135-23, a resolution of the City Council of the City of Riviera Beach, Palm Beach County, Florida, authorizing the purchase of a mobile command center for the city's police department, authorizing the use of Omnia Partners Cooperative Purchasing Contract number 128867, authorizing the Director of Finance and Administrative Services to make payment in the amount of $705,598 to Faber Specialty Vehicles from project number 24007 and providing for an effective date. Mr. Chair, we do have public comment cards on this item. The acceptance of public comment cards for item 11A is now closed.
Motion to approve resolution number 135-23.
Second.
Motion been made and properly seconded. Mr. Evans?
Mr. Chair, members of the board, I'll turn this presentation over to Police Chief, Mr. Michael Coleman.
Good evening, Chairperson, Councilperson, City Manager, John Devin. We're trying to, we received.
Chief, microphone. It's just the residents at home need to hear you.
I'm turning the appreciation to, over to Chief Madden. He's gonna do a presentation.
Thanks, Chief Coleman. Welcome, Chief Madden.
Good evening, Chair Lawson and Council. This item seeks the board's approval for the purchase of a mobile command center. As you know, back September 6th, we received approval from the council to execute the grant contract with the Florida Department of Law Enforcement. So we have been awarded the grant in the amount of $600,000. We also received an additional $125,000 in the FY 2024 capital improvement plan. So we're seeking to purchase a 38-foot Freightliner mobile command center in the amount of $705,598. This is a fully equipped, customized mobile command center with all, the latest satellite, Wi-Fi, network hardware, generators, and all the equipment we need to operate. We are purchasing the mobile command center under a cooperative purchase agreement. The Omnia Partners, Omnia Partners contract number 128867. And we can answer any questions the council has.
Thank you, Chief Madden. Councilman McCoy, I know you had some questions earlier.
Thank you. So I don't understand. Was it not an option to use the forfeiture funds? Because I know I looked at the statute, it specifically allows for specialized equipment to be purchased under forfeiture funds. So why would we not use that option instead of our capital improvement dollars?
Our current balances wouldn't support that additional funds.
So why not, deplete that first before you go into the capital improvement plan dollars, because those monies can be used elsewhere. I guess this is a finance question, but I don't know what the balance is, but I'm just kind of curious to know. Because here's why. If that fund is specifically statutorily limited, why not use that first and then go to the capital improvements later? Just seems like the real easy thing to do, and that's my request. I mean, we do have a lot of capital needs, and I think I shared with the manager. I mean, we have, and I don't know whatever came of the capital request that we considered for equipping code officers with cameras, but I thought this was probably a better swap.
Mr. Chair, if I may.
Mr. Evans, go ahead.
The request to outfit our code compliance officers, which staff provided me with the information as of today, is about $43,000. So they're making funds available to be able to utilize that. But I think with regards to the forfeiture funds, it would still have to be a two-step process, because we would have to deplete that account, and then there's still a funding deficit that we would have to come back before the board to be able to facilitate the capital expenditure. And then what is the lead time with respect to moving forward with this acquisition, and what will the delay cause as it relates to getting the unit in hand?
Yeah, we are under a very tight time constraint on this. That's the reason we're using the cooperative agreement. We did talk to several vendors, and there were very few that could deliver this vehicle within the grant timeline, which is by June 30th of 2024.
Mr. Evans, I'm not sure what that has to do with anything. This is done on a reimbursement. So they were going to purchase it, and then the grant dollars were going to come in. So why is that important?
Well, in order to expend the monies from the forfeiture funds, we'd have to bring that to the board, and then also to be able to identify the remaining balance from the capital budget. It's a two-step process that would have to facilitate coming before the board. Plus, I don't know if the chief has any other expenditure needs for forfeiture monies. It could be for other equipment and other purchases that he has for operational needs. And so that's why that was asked for as part of the budget process, to be able to provide the chief flexibility for other equipments and needs he may have. Chief, I don't know if you wanted to speak to that.
Thank you, sir. I'm not sure the balance of our forfeiture dollars, so I can't talk about how we'll use those funds in that forfeiture line item.
Right. Well, thank you for, when you do decide, it's a recommendation because the statute says the governing body or the board has to authorize it. But clearly, I'm just like, if we commandeer money, valuables, and it goes into this fund, why not put it back on the streets to do some good instead of taking monies out of the taxpayers' dollars? I guess in this reverse situation, use the bad money and turn it into good money. But instead, we're being asked to approve dollars that's coming out of taxpayers' pockets, when I would much rather be doing some other critical services for those. Like we just had those folks in here talking about the drainage issues in Lone Pine. I mean, this is what policy making is about. I mean, you don't have to like my approach, but Shirley Lanier's husband did steal my signs and say, call my wife. I mean, that's what he said. I've seen it. So, I mean, that's what this is about. So that's all I have.
Board members? Madam Clerk?
Councilperson Botel?
Yes.
Oh, I'm sorry, you're right, Mr. Lozman.
Welcome, Mr. Lozman.
Dane Lozman. Thank you, Mr. McCoy. You made a very good point. For the last 17 years, going back to 2006, when I was arrested the first time at the dais back in November 2006, I have advocated for the sheriff's office to take over police servicing in Riviera Beach. I've said it dozens of times, or maybe a dozen times, maybe more over the years. And here's a perfect example why. The Palm Beach Sheriff's Office has all kinds of command vehicles. They have helicopters. They have 7 or 8 boats right there at Phil Foster Park. They provide police services in Lake Park. They provide police services, the Sheriff's Office in Lake Worth Beach, where 36,000 people live. 4,000 people less than live in Riviera Beach. The point is, why are we buying a $700,000 command vehicle? If we had the sheriff's office in here, they would integrate most of the police officers, the men and women would be integrated in. Maybe a third of them wouldn't. Guys like Summers would never make it in the sheriff's office. But the point is, they have so much more capacity than we have at the little city. Helicopters, boats, command. I mean, narcotics. It's such a superior. It is such a superior alternative to having your own police department. Many municipalities have figured that out. Here's an example. Why do we need a $700,000 command vehicle when the sheriff's office already has that capability? Has anybody ever sat down in a workshop and said, how much money is our police budget costing us versus what capability can the sheriff's office bring to Riviera Beach? Has anybody sat down and looked at that? The quality of officer, the training, all the different departments the sheriff's office have that we don't have? Has anybody bothered to do that? You know, when my floating home was vandalized, where it was totally tore apart on my property here earlier in the year, the Riviera Beach police boat didn't go out there and take the report. The sheriff's boat had to go out there. It's like a part-time gig for the Riviera Beach police boat to be on the water, but they have 6 or 7 boats ready to roll at 24 hours a day right at Phil Foster's. So the sheriff's had to come out and take the police report. Okay, so I just look at this as just another example over 17 years, $700,000. At the end of the day, that capability would be more than matched if we had the sheriff running the police department. There's been a lot of scandals over the years in the Riviera Beach Police Department. Go back to Darden and what went on in the old days. You get a better product, a cheaper product going with the sheriff's office, and I would say we need to take a look at that again.
Thank you for your comments, Mrs. Lozman. Madam Clerk, any additional comments?
No, sir, that's it.
And I guess just for clarity's sake, what Chief Coleman, the amount that we're expending is $705,000, but I believe $600,000 was received as a grant from the state?
Yes, sir.
Okay. So our cost is only just 105.
Yes, sir.
Okay. So I guess for clarity, we received that grant as one of the legislative priorities that we've received from the state. So that 105 that we're spending, I agree with Councilman McCoy, forfeiture funds. I want us to get an update on where those expenditures are, what's the amount that we have, and make sure that we're getting them back out into the street with positive and good programming. So I do want to leave those funds with you available so that you can actually have them to do good programming, which you will do, and continue with the process. So I'm going to support this item. Thank you, Chief. Board members? Madam Clerk?
Councilperson Botel?
Yes.
Councilperson Mel Anderson?
Yes.
Councilperson McCoy?
Yes.
Chair Pro Tem Lanier?
Yes.
Chairperson Lawson?
Yes.
That vote passes, Mr. Chair, unanimously.
Thank you, Madam Clerk. Last item was moved to consent, discussion, deliberation. Mr. Evans, it is now 9:40. I know you have 3 items that you wanted to address. I'm not sure if the council is going to be going past extension. So can I get comments from the board first before we go into your comments?
Yes, Mr. Chair, or I can answer any questions that the board may have on these items.
I know we just have them. We just got them on our desk, so we haven't really had a chance to review them in detail. I can't ask the board if they're interested in extending past 10, but typically no. I will let the board comment first, and then we'll go into your items, and if we want to extend, we can. I'm going to go into discussion deliberation, starting with, I'm sorry, committee reports. Councilwoman
I'll
Botel.
try to make this quick. On September 21st, I attended the Mayor's Literacy Lunch to kick off the Read for the Record campaign that's sponsored by the Palm Beach County Literacy Coalition. And this year, Read for the Record is October 26th. If you're not familiar with that, many people may not be. This is a day when municipal leaders, business leaders all across the county read to children one particular book. I have that book for each of my colleagues, a copy. I'll pass that along. This year it's With Lots of Love by, thank you, by Jenny Torres Sanchez. And I'm asking that we take some time. I know that many of us will be out of the city on October 26th, but Walter Stevens has agreed to videotape us if we want to take some time. Maybe we can each take a section, or Walter can tape us reading the whole thing, and then he can piece together so that we make a little video of all of us reading. And then the IT department has agreed that they can put something up online so that kids can click on that and be read to by city council. So I think it would be a nice thing to do if you wouldn't mind. If you're interested in reading, contact Walter and let him know what day you might be available to be taped. If people watching are interested in reading, they can contact our children's librarian, Charmaine Arnold, and her number is 561-845-4195. On September 21st, I also attended the Florida League of Cities Executive Committee meeting and the general session. I attended on September 26th, the Palm Beach North Chamber of Commerce Resilient and Connected Task Force meeting, as well as the Economic Resilience Tri-County Economic Resilience Work Group meeting. On the 27th, I chaired the Palm Beach County League of Cities Board meeting and general session. On the 28th, I attended the Palm Beach North Chamber of Commerce Economic Development Committee meeting. On the 29th, I attended the Intergovernmental Issues Forum, and we're going to take on a very important topic as an intergovernmental forum, and that's the ability of the county to charge us as municipalities for lighting that goes on county roads. So I'll be asking Mr. Evans to give us some advice from our own engineering department on that topic. And then today I attended the District 1 lunch for the Palm Beach County League. I have a couple of comments if you want me to continue.
Thank you. Well, any other committee comments from the board?
Yes.
Councilwoman Miller Anderson.
So for the Palm Tran Advisory Board, I'm not sure if Ms. Posey Blocker reached out to each council person, but I know they did send an email to Mayor Felder because they're looking to have about 10 minutes on one of our upcoming city council meetings to talk about the service changes that will be happening here in the city. I think I mentioned before, they were looking at doing something with like a on-demand type thing where they could, basically you can get an Uber. And so this is something that they're looking at doing. So they want to be able to come and present the changes that are being made. I mean, looking at the memo that Mr. Evans sent out, I guess if we go by this, the next council meeting wouldn't be until November 1st. So I can reach back out to them and see if they want to do the CRA meeting or if they want to wait until November 1st to get on the agenda for about 10 minutes. But there are some changes that they are looking to make that will impact some of our residents. But I think it could possibly work in a good way, but it is a change. So they do want to be able to present that. That's it. Thank you.
Thank you, Ms. Anderson. Committee reports? Statements by the council and mayor, starting with Dr. Botel.
On September 21st, I attended the Housing for All Committee. I think I mentioned in the past that Riviera Beach is being used as a model for the county housing plan. So we have a group of about 4 or 5 subcommittees that are working through the various components of the county plan to see the status of Riviera Beach with regard to those components. And that work is moving along well. And I also want to let people know that the Palm Beach State College / City of Riviera Beach College Credit Certificate Program is alive and well, but really in need of more students. So if you're interested in a free college education and you qualify for financial aid, please contact Valerie Grimsley or Mary Small. Valerie Grimsley is vgrimsley@rivierabeach.org. Mary Small is msmall@rivierabeach.org for details. It's free and it's college and it's right here in Riviera Beach. That's all I have. Thank you.
Thank you, Dr. Botel. Pro Temp Lanier?
Yeah, the past weekend, the Long Pine Park grand opening was held. The residents were able to engage with and enjoy newly installed workout equipment and a repaved tennis court. It was a very, very well-attended event. The residents who were there in Long Pine supported the project, and there's still more to come in terms of making sure that that park is a representation of the people here in the city of Riviera Beach. But I also want to say this. Mr. McCoy constantly attacks me personally in these council meetings. I have filed no less than 5 police reports against Mr. McCoy in regards to his constant, and it seems as if it's women in general and Black women in particular that he attacks. And it has gotten to the point where the last police report that I filed, I was in fear of my life from this man. Fearful. I'm a Black woman, and men are very misogynist, like Mr. McCoy is. And these type of things are making me nervous coming to meetings because it is this constant attack. The lies that he tells, I don't have a husband, but he still says these things. And the venom in which he says them. It is not what he says, it's how he says it. I can feel the vibe from way over here. And I'm very fearful of that. And I want to put on record of how fearful I am and the 5 police reports that I have written against him and reported to the chief of police, both of them, the city manager, the city attorney, because it's getting out of hand and I'm very fearful. So I want that to be known and put on record that it is misogyny and it is an attack on Black women in particular. And Chair, you need to, if you want to regulate the public, you also have to regulate this board in terms of having a civil conversation with each other. We are here to do the business of the city. That is it. It is for the business of this city. I don't have time to make remarks like this because this is about the business of this city. But I'm afraid, and I want it to be on record that that is so. So if we're going to have these kind of conversations, these personal attacks, Chair, you need to regulate that just as well as you regulate the public and when they attack us up here. So thank you.
Thank you, Pro Temp. Ms. Miller Anderson?
Have none.
Councilman McCoy?
Of course, I got something to say. My name is Trodrick McCoy. I got one, Coach. Mr. Evans, I'm getting a bad report both from members of the Police Benevolent Association, collective bargaining union, regarding the negotiations. And it really startled me because I got reports from the International Fire, IAFF, International Association of Firefighters members about negotiations occurring, which really don't occur. They show up, the city's not ready. We've not gotten a report back on where we are with collective bargaining, but it seems to be a pattern here, and we've not heard anything for at least a few months. Can you give us a report on what's going on, especially if members are leaving from, they do those 24-own schedules, and then they come in to negotiate in good faith, and for whatever reason, representatives of the city aren't prepared for whatever reason? And I still reserve, Mr. Chair.
Thank you, Councilman. Go ahead, Mr. Evans.
Mr. Chair, if I may,
please.
I can provide something to the board in writing with respect to the status of those within the next 24 hours. I know that there is ongoing conversations. I believe there was a meeting this week with regards to IAFF. And as you can imagine, union negotiations go back and forth specifically as it relates to fire, because what fire has proffered is something profoundly different than what we've ever done with respect to level of service and hours. And so there is a lot of calculation. And so there is some touch and go with respect to that. PBA
We've had multiple conversations with regards to that, and I think Mr. Sherman did provide an update that they are calculating some information, and so we anticipate hopefully being able to resolve all those issues before the end of the calendar year. But I can provide you all with writing with respect to that, and then set up individual sessions with you all for the purposes of bringing you up to speed on those two labor unions.
Okay, I would appreciate that, but how do you, I mean, what's your report, or what can you offer us in return as to what happens when they go to a collective bargaining union meeting and staff is either not prepared or not there or delayed? It's like, you know, they walk into here pessimistic about having a fruitful outcome if that's the way the city is treating it, or the representatives of the city.
Mr. Chair, if I may.
Stevens, go ahead.
If I can allow for the assistant city manager to speak up, who's the administration representative on the union negotiation for PBA, and then Chief Kurd can provide some specificities on the fire side. I don't get involved in the union negotiations until we get close to what the terms and conditions of the contract are, but staff can provide an update with respect to the conversations and discussions, or the remarks that are being made by the union membership to board members.
Welcome, Ms. Jacobs. And before we do, board, do we want to entertain extending this meeting? The time is now 9:55.
Well, then make a motion to extend to 10:15 so that we could, I know you all don't want to have all of these meetings, so I think it's important that we talk about this and the legislative priorities. All right, 10:15.
Motion been made. Do we have a second?
Second.
Motion been made and properly seconded. Madam Clerk?
Councilperson Botel,
Yes.
Councilperson Miller Anderson,
Yes.
Councilperson McCoy,
Yes.
Chair Pro Tem Lanier,
Yes.
Chairperson Lawson.
Yes.
That vote passes, Mr. Chair, unanimously.
Thank you. Welcome, Ms. Jacobs. Welcome, Chief Kurd.
Thank you, Mr. Lawson. It's okay.
Please.
Thank you, Mr. Evans, for the opportunity. With regards to the PBA contract, there was an internal meeting this afternoon amongst staff and our outside legal counsel. Will be going before or meeting with the PBA representatives on October the 24th with regards to the statement that the staff is not prepared, not to refute that in any manner at great length, but I would, in my position, it is just the opposite in terms of who's prepared when we get to the table to discuss those issues.
Councilman McCoy, go ahead.
Well, you know, I've asked this before. Can we be provided with an update? I want to know what articles are outstanding, because obviously, if we're at an impasse, which this has probably been the longest collective bargaining negotiations that I've seen or heard of, I want to know what those issues are, and it should come back to the board for us to be the authority that makes the decision on whether or not we're going to, you know, decide to move past that.
Mr. Chair, if I may.
Mr. Evans, go ahead.
We can provide some commentary with respect to that in a memorandum to the board. But I can tell you that there has been contracts that have been proffered by the city, and Ms. Jacobs can speak in more specificities. Have we received a contract from PBA or a response to a contract or an article with respect to that?
Based on my recollection, may I?
Please, Ms.
Thank you.
Jacobs.
Based on my recollection, there are only a couple of items that are pending still between the city and the PBA representatives.
Okay, so do I need to get a meeting with the appropriate people to find out what they are? Because that's what I'm asking. What is possibly taking, you know, this has now been over a year and a half of negotiations.
And
so, I'm sorry, Mr. Evans, with regards to Mr. City Manager Evans' comments, I think it probably would be more productive for us to memorialize something to you in writing.
Okay, but that,
Mr. Chair, if I may.
Mr. Evans, go ahead.
And certainly, we don't want to engage in negotiations in a public setting, because obviously, you know, we are still working through the contract language. And certainly, if union members are communicating with board members, that is really outside of what the purview of the collective bargaining process is, because we don't come and share with the board unless in an executive session to talk strategy about a union contract. And so we can sit down and provide some updates with you all, but we can provide you something in writing. But it would be staff's recommendation that we don't get into negotiations or discussions with with respect to specific provisions in the contract that there may be left unresolved.
Okay, is there anything to share with us on IAFF?
Chief Kurt, if you.
Yes, sir, there is. Good evening, Chair, Council. I'll try to make this quick. We had workshops early on with IAFF. What they are proposing is so different. It's only being done by a few departments. It has huge implications on staffing, finances, benefits. So there's a lot of research that needs to go into this, and I won't be rushed. I won't let the city be rushed into bargaining into something that we can't vet and make sure that it is in the best interest of the firefighters and our community. So we're in the process right now. We met on Monday. We've also met yesterday. Was that today, Mr.? It felt like yesterday. I'm sorry. We met today, and we're also meeting with the union again. The last time we met with them, they put their proposal out there, and it was so big and so comprehensive. We had to take it back with us just to digest it. We are now going to send back our counter proposal. And if this new revolutionary staffing model don't work, we go back to the table and negotiate a normal contract. So it's not that we're not ready. It's we're doing our research and our due diligence to make sure that we do it right, and we're doing it as fast as we can. And let's not be mistaken, there were meetings proffered that they canceled as well. So in all fairness, we are working as hard as we can, and we're just a couple days past what the deadline would have been, because this is a big deal.
Okay. Next thing, Mr. Chair. Mr. Evans, I have some outstanding public records, particularly the mayor made it a point to say that the chief vetted out Abe Elam, and I'm waiting on the results of that, and I've still not been provided. I'm waiting on public records from earlier this year regarding Shirley Lanier's and her text messages. So like what is happening with public records? Is there a desire to fulfill the statutory obligation of furnishing these public records, or is just going to be complete disregard and a requirement to bring legal action?
Mr. Chair.
Mr. Evans, go ahead.
With regards to, I'm not the custodian of record. I don't have those records. And so I will get with the city clerk immediately following this meeting and find out what the status on that. And they will provide you a follow-up correspondence tomorrow, councilperson.
Okay, lastly, thank you for sharing with everybody that you filed 5 police reports, because that should say something. If you filed 5 of them, clearly nothing has occurred. And I'm not sitting up here telling you what I heard. I'm telling you what I know from firsthand observations, that your husband stole my signs and then stated specifically, went to the investigating officer, called my wife, Shirley Lanier. That's all I have, Mr. Chair.
Mr. Chair.
Councilwoman Botel.
I can't be quiet any longer. I'm going to ask the city manager to do, I was going to say me a favor, but I think it would do us all a favor. I think we have to have some set of rules by which we play this game, by which we behave up here. I too have been bullied. Black women don't have the whole, don't take the whole thing. It's women, and maybe it's old women, I don't know. I too have been bullied. I have made complaints to HR about the behavior of one of my colleagues. And it is not easy to sit here and see staff be bullied, to listen to colleagues be bullied. Something has to change. People will not want to work here any longer when they see the behavior of certain people from this dais. And I think we need a set of guidelines by which we should operate. Things cannot continue to go on this way. I am afraid as well. And I sympathize with Councilwoman Lanier. I just think that we need to have at least some set of guidelines that people have to adhere to when they're elected to serve on this body, such that they're not bullying staff. There's a way to make your opinion known. There's a way to express yourself, and it doesn't have to be through bullying. And that's all I'm going to say on that. And thank you. Have a good evening.
Thank you, Councilwoman Botel. Questions, Mr. Evans. The ribbon cutting for Lone Pine. The communication, well, who was in charge of sending that communication out? Because thank you to Ms. Jacobs and Ms. Collins. I got it last minute notice, and I was able to kind of show up towards the end after I finished prior business, prior obligations. But who is responsible for sending those out?
Mr. Chair, if I may.
Mr. Evans?
That is handled through communications. I believe that it was in concert with the original date that was set forth, and then there was a conflict for the residents and the members of the HOA. So the date changed, but staff's responsibility of disseminating that information.
If I can ask again, I believe that we've had the support from my colleagues, but if I can get the support again to just give clear direction, Mr. Evans, any event or activity that the city's hosting, email communication is sufficient. I want to know that my colleagues want to have an opportunity to be at everything we're doing. If it's a mixer with you and the mayor, if it's a police event, any activity that's happening in the city, I just want to be notified when it's going out so that we can know and have an opportunity to attend and just kind of support the staff and support our residents. I don't want to have to miss anything or hear about a last minute notice. And I got a phone call from Ms. Jacobs the night before. I didn't have my phone with me. And then I got a call that morning from Ms. Collins. So that's really the only way that I knew about that ribbon cutting that morning. So if we can't just make sure communications, as soon as they have the flyer, I don't want to see it on social media. I want to know that we've been notified about it before it goes out to anybody else.
Mr. Chair.
Feedback received from my colleagues. Respectfully, I agree and understand the First Amendment, right? I understand Congress shall make no law, but I also do agree with my colleagues when it comes to a sense of decorum. We set the precedents here on this board, and I just want to make sure that we can disagree without being disagreeable. Personal conversation and dialogue and personal attacks just do not lay any place here on this board, on this dais, and we're trying to move the city forward. If we expect the residents to have some type of sense of decorum and respect, we have to have the same and lead by example. There's been a lot of back and forth with all of us as colleagues, and I was hoping that we were starting to turn the corner because the city was seeing such great accomplishments. I want us to get back to that because when we first got here, we started with the holding hands. Then we moved forward with the divided dissension, support of other people, and going back and forth, and it didn't actually do anything for our community. We're seasoned electeds, and we don't need to be going back and forth with the semantics, with the attacks, with the personal politics that get in the way of moving the city forward. Everybody was elected duly, and I just think that we need to do that. So feedback from Councilwoman Pro Tem Lanier, I will be governing these meetings effectively and efficiently within the rules and regulations of Robert's Rules and make sure that I hold them accountable for every person that speaks on this dais, and I received that. And just moving forward, colleagues, if we just can't remember that we lead by example, the entire city's looking at us to lead, and we have to be held at the same standard we expect of everyone else. I did have some feedback on some of the items, Mr. Evans. We've only extended till about 10:15, so I wanted to take the lead with the meeting schedule. If we could move December 13th meeting, the CRA meeting, colleagues, if would be an objection to possibly moving that to December 6th, having the city council and the CRA meeting on the same night so that we could just have the rest of the December off. I think that'd give us an opportunity to close out both meetings if that's feasible, Mr. Evans. And that would be my feedback for the consolidated meetings structure.
Mr. Chair.
Mr. Evans, go ahead.
That would, with the pretense that will be an extremely long evening because there's a lot of things that we've had to shift and move from some of the meetings that we haven't been able to get some of the agenda items. So if it's the pleasure of the board, nothing is outside of our ability to be able to execute, but it will be a long evening. We're going to be also intentional about the items that we bring before you. So we can make it work if that's the board's
If we can eliminate the for that meeting, possible any presentations, any awards, anything that would take up any time outside of the business of the city, and then any items that could possibly be consent items that we could discuss moving, leading into that meeting, and be prepared. I think the board does need a break. A few of my colleagues have said that they need some time to just kind of be away, disconnect, and be with their family. So that may give us an opportunity with maybe having a longer meeting and colleagues just being prepared to know that we may have to go past 10 that night. And if we're okay with that, I would actually like to take that December off for the board, just to refresh so we can start the new year well.
question.
Any other comments from the board? Councilwoman Miller Anderson?
When is National League of Cities? That's not one of those.
National League of Cities is November. I'll pull it up real quick.
Like the middle?
Is November 16th.
Okay.
Yeah, 16th, 17th, 18th.
Okay.
So any feedback for that December meeting? Because that was the only thing that I saw on that schedule that I think that might help us, because then that gives us a full month, a month and a week off. Board, Kassamba's okay?
Yep.
Pro Temp's okay? McCoy, Millerson, good? So, Mr. Evans, if we could, we are realizing that it'll be a longer meeting that night, but we'll just try to make it work within the timeline and then also with the items that you put on there. Thank you. Any additional comments from the item bulletin for Mr. Evans in regards to dates? Are we good with that schedule? Good? Okay. Mr. Evans, legislative priorities?
Yes, Mr. Chair and members of the board, I've put together a list of legislative priorities as well as the priorities that we were receiving from departments for the purposes of a legislative appropriation. So this is an opportunity for the board to provide any additional feedback or commentary with regards to this. In this document, it also enumerates your state priorities as well as your federal priorities. This is a culmination of a lot of the conversations that the board has had, and staff has been writing notes with regards to those items for the purposes of tracking them. So the real meat and potatoes of this is the projects that are identified on this list. Is the board in concurrence that these are projects that we are to provide to our lobbyists for the purposes of seeking appropriations? The other items that are legislative public policy initiatives, those can be changed and modified and tweaked. The projects are the ones that we go ahead and provide to Mr. Pittman and his team for the purposes of attempting to secure funding. And then we also will send these projects to our lobbyists in Washington, D.C. And I do have staff available for any questions on the specific projects.
Mr. Chair.
Councilwoman Botel, go ahead.
Mr. Evans, I'll be in Washington, D.C. with the fast fly-in. So if maybe you and I can meet before I leave and go over these in case there's something you want me to say to anybody in particular.
Councilwoman Botel, what's that date you're going to be there?
I think it's the 17th and 18th. Let me look.
October?
Yeah.
Yep.
pretty
And
sure
same,
it's the
same
17th
with
and
me, Mr. Evans. I'll be there October 23rd. So, I'm sorry, 24th. So 23rd, 24th. So if we can have a one-on-one meeting with you, Assistant City Manager, Ms. Jacobs, and any other staff that you think would be a priority. Any additional comments for legislative priorities? And
The
school district.
Yes, Mr. Chair. Pursuant to the direction provided by the board, I did send a correspondence to the superintendent's office. The superintendent's office provided correspondence, which I provided to the board, that stated that at their board meeting, they were not inclined to support a discussion with the Riviera Beach City Council, citing that this would be something that they would have to have the conversation or the potential conversation with 39 municipalities. The other alternative that was proffered by the school district was providing for an opportunity for senior level staff to allow for, at certain meetings, to have the educators and the principals provide an update from each of the educational institutions. Staff has not responded nor accepted that particular request. From the purposes, I didn't think it complied with what the board's desire was with respect to the conversation, because we know, and we've done it in the past, we always welcome our principals to be able to share how our students are doing. But I thought the board wanted to get into more substantive public policy discussions with respect to the state of the educational status of our students here in Riviera Beach. And so I'm seeking direction from the board as to how you wish to proceed. I do have a list of questions or opportunities for discussion, but if the board can provide me with direction, I can move in the fashion that is complementary to the board's request. I can push on the superintendent's office. One of the things I think we should consider, Mr. Chair, if the board would indulge me, is that since our schedule for the holidays does provide for some flexibility, I think it would be a good opportunity for a field trip to go to the school district. I think it's more compelling that if the board has a unified approach with regards to what is happening in our school system, I think it would share a clear and distinct message as well. One of the things I also think the board should consider is the adoption of public policy from the City Council of Riviera Beach stating your desire to see the academics in this community improve and improve to where the day where all our schools are A schools. Because I think if the board was to present a resolution that is adopted by the Riviera Beach City Council to really memorialize the partnership and the desire to see our students succeed, I think it will go a long way. And so I'm seeking direction from the board as to how you wish to proceed with regards to this item moving forward.
Mr. Chair,
Councilwoman Patel.
I've answered your questions already. Number one, no, we're not accepting the proposal. From my point of view, not accepting the proposal. To proceed, we can speak with the principals, and any other time, no. Number two, yes, we should re-engage on a policy level. We should persist in our quest for higher level engagement, and I love the idea of going to them personally. Number three, yes, we should have a community mobilization strategy. We should initiate a community-driven campaign to draw attention to these educational disparities. Number four, yes, we should collaborate with elected representatives. We know that Edwin Ferguson and other board members, school board members, are interested in seeing our children do better. And whatever other strategies you can come up with, I'm sure that you can come up with a few. And I certainly don't think it's sufficient to have the principals come and speak with us. Just my opinion.
Board members, the time is now 10:15. No,
I am so tired.
so we'll meet individually with Mr. Evans to go ahead and go further into the discussion with priorities for the school district.
Mr. Chair,
Mr. Evans?
can I just really briefly before we conclude, is there, you would like for me to correspond based on the conversation that I'm saying with the school district that we want to have a more robust conversation?
I would be in agreement with that, board.
Yes.
Yes. Okay. No further business of the city? Meeting is adjourned.